come to order and want to welcome everyone in the committee meeting room and those following along online, and as well, welcome to our committee members. I understand we will have a few more committee members joining us here in the meeting room. And do we have members who are appearing online? If you are, can you please, we'll just have Legislative Research Department identify who's online.
Thank you, Madam Chair. Jordan Milholland, Legislative Research. So online this morning, in addition to our staff, we have Representative Wassinger, Senator McGinn, and Senator Faust-Godot.
Thank you for that. Committee, we do have a quorum, so let's take a look at the minutes. Those were sent to you previously, and do we have a motion or any other discussion?
Madam Chair, I move that we accept the minutes as presented.
And is that a motion to approve them as well, Representative?
Yes.
Madam Chair.
Go ahead.
I have a question about the minutes.
Yes.
Are we referring to minutes of April?
Just a moment, please. We are looking at minutes from the April 25, 2024 meeting. Yes.
Yes. So, Madam Chair, I have a question. So, some of us are listed as absent but excused. I believe we were online that day. So, does that mean I thought it would say that we were present but attending virtually as opposed to absent. Could someone clarify?
Thank you, Senator. And looking at the minutes, we do have in the draft members absent but excused. There are listed you, Senator Faust-Godot, Senator McGinn, Representative Carmichael, and Representative Sutton. So if those members were present online, that would not be absent. So Senator Faust-Godot, we would need to amend the draft of the minutes to indicate that you were not absent, but were present. Do we have any others who are listed as absent but excused on the draft of the minutes who need to have that changed? Not seeing any. Do we have a Representative Wassinger, do you want to still continue with your motion to approve the minutes now as they've been changed as amended? Thank you. Is there a second and or further discussion? Senator Francisco.
Thank you, Madam Chair. I believe that Representative Carmichael is on his way in and would just like to give him the opportunity to, he might have a better memory. I'm happy to go ahead and second this and only change it if we need to, or we could defer this.
Sure. Let's go ahead and wait until Representative Carmichael is present and has an opportunity to make any proposed changes to the minutes if he needs to. So committee, we are going to put aside the motion and seek a second later when we have Representative Carmichael present. With that, then, let's move on to our next item of business, and that would be Department of Agriculture, Division of Animal Health. So please come to the podium, and I don't have the name of the conferee. So welcome to committee. Please introduce yourself.
Thank you, Madam Chair, and members of the committee for the opportunity to appear. I'm Kate Langworthy, staff attorney for the Kansas Department of Agriculture's Division of Animal Health. Today, I also have present on behalf of the department and available to answer questions our Animal Health Commissioner, Dr. Justin Smith, and Assistant Animal Health Commissioner, Dr. Sarah McReynolds. Today, I'll be addressing proposed amendments to 2 regulations relating to movement of livestock into or through Kansas, KAR 9-7-1, and KAR 9-7-14, and revocation and replacement of regulations under Article 10 of KDA's Kansas Administrative Regulations relating to public livestock markets. These changes reflect current management practices and standards of the livestock industry, update and modernize various requirements for public livestock markets and occasional livestock sales in Kansas, and organize the regulations to allow them to be more easily read and understood. These regulations are authorized by several statutes. KSA 47-607D, which empowers the Animal Health Commissioner to adopt rules and regulations to protect the health of domestic animals. KSA 47-610, which empowers the Animal Health Commissioner to establish quarantine, sanitary, and other regulations as necessary to protect the health of domestic animals. KSA 47-674, which authorizes the Animal Health Commissioner to promulgate rules and regulations to develop and implement a voluntary premises registration and animal identification and tracking system for Kansas. KSA 47-1001A, which directs the Animal Health Commissioner to adopt a public livestock market application fee amount by rules and regulations. KSA 47-1001E, which directs the Animal Health Commissioner to adopt an animal renewal market license fee amount for public livestock markets by rules and regulations. KSA 47-1008, which empowers the Animal Health Commissioner to promulgate rules and regulations as may be necessary to govern the sale of animals through public livestock markets. And finally, KSA 47-1832, which authorizes the Animal Health Commissioner to establish rules and regulations on disease control programs for and on the sale and importation into Kansas of farm animals and exotic animals. These proposed amendments were developed with the assistance of a number of organizations comprised of stakeholders affected by them, including Kansas Animal Health Board, KDA's Public Livestock Market Working Group, the Kansas Cattlemen's Association, Kansas Livestock Association, the Kansas Elk and Deer Association, Kansas Farm Bureau, Kansas Horse Council, the Livestock Marketing Association, Kansas Pork Association, Kansas Sheep Association, K-State Research and Extension, Kansas Veterinary Medical Association, and the United States Department of Agriculture's Veterinary Services. A public hearing regarding the proposed amendments is scheduled for July 2nd, 2024, and notice of such was published in the Kansas Register on April 18th. Because the public hearing takes place after July 1, KDA will complete the new EIS form once it's available and submit it to the Office of Budget for approval prior to publication of the regulations, pursuant to requirements of 2024 House Bill 2648. Because this is admittedly a large set of regulation updates, I'll provide a brief summary of the substantive changes to Article 7 and Article 10, and then stand for any questions that you may have. First, our amendments to KAR 9-7-1 clarify situations when livestock or exotic animals may move into Kansas without a certificate of veterinary inspection, and further state records related to animal movement and identification, which shall be confidential for the purposes of animal disease traceability. Our amendments to KAR 9-7-14 set forth identification and testing requirements for equine animals offered for sale in Kansas, changing ownership, or being used for exhibition purposes, in addition to the existing requirements for those equine animals entering Kansas. All of the existing regulations, ranging from KAR 9-10-1 through 9-10-40, are revoked and replaced with the following regulations. KAR 9-10-41 lays out definitions relevant to and used throughout Article 10, Chapter 9 of the regulations. KAR 9-10-42 prescribes requirements for construction, sanitation, and maintenance of public livestock market facilities, while allowing more flexibility for the operator, so long as the risk of physical injury to people and animals is minimized, adequate drainage is achieved, and facilities are maintained in a clean and sanitary condition. KAR 9-10-43 maintains existing limitations on the use of public livestock markets, while allowing exceptions for the facilities to be used as a collection point for livestock moving directly to slaughter, to house livestock or exotic animals during an emergency response, and to house strays under the custody and control of law enforcement. KAR 9-10-44 maintains the existing requirements for cleaning and disinfecting a public livestock market facility and vehicles, but provides the information in a more readable format than formerly provided. KAR 9-10-45 maintains the existing requirements for quarantine pens and facilities while clarifying the role of the market veterinarian in maintaining any necessary quarantine. KAR 9-10-46 maintains the existing requirements for the quarantine of diseased or exposed livestock or exotic animals at a public livestock market, but again provides the information in a more readable format. KAR 9-10-47 combines several former regulations governing diseases, injuries, or conditions that may render livestock or exotic animals unfit for sale, limitations on that sale, euthanasia, removal, or disposal, and puts them into a more readable format. The regulation lists the diseases, injuries, and conditions that may render livestock or exotic animals unfit for sale and further sets forth requirements for removal, euthanasia, or disposal of livestock or exotic animals rendered unfit for sale. KAR 9-10-48 maintains the existing requirements for issuance of certificates of veterinary inspection at a public livestock market or an electronic auction, and provides an additional requirement for submission of those certificates to the Animal Health Commissioner. KAR 9-10-49 maintains the existing requirements for consignment of livestock at public livestock markets while providing additional clarification to provide disease mitigation capability and awareness for public livestock market operators, market veterinarians, and consigners. KAR 9-10-50 maintains existing requirements for special sales at irregular intervals while clarifying that ensuring that any sale hosted at a public livestock market meets state and federal regulations is the responsibility of the public livestock market operator. KAR 9-10-51 maintains existing requirements for public notices required to be posted at the public livestock market while allowing new flexibility with respect to the exact wording and formatting of the notices. This regulation also provides for additional disclosures about trichomoniasis in cattle. KAR 9-10-52 maintains existing fees for individuals who hold anywhere from 3 to 12 sales per year, while increasing the fee for individuals holding 1 to 2 occasional livestock sales from $25 to $50. This regulation also prescribes new record-keeping requirements and submission requirements for those records. KAR 9-10-53 maintains existing requirements for bovine animals sold at public livestock markets while providing additional sale restrictions related to trichomoniasis in bovine animals persistently infected with bovine viral diarrhea virus. The regulation further identifies specific bovine animals that must be officially identified at a public livestock market. KAR 9-10-54 maintains existing requirements for record keeping and labeling and prescribes new requirements for pylori testing in poultry sold through a public livestock market or an occasional livestock sale. KAR 9-10-55 establishes requirements for horses, donkeys, zebras, and hybrids of any of those being sold at a public livestock market or occasional livestock sale. This regulation requires that any such animal being sold must be accompanied by an official negative equine infectious anemia test at the time of sale and sets forth record-keeping requirements. KAR 9-10-56 maintains existing requirements for swine being sold at a public livestock market or occasional livestock sale and requires swine offered for sale to be identified with a form of official identification. This regulation further sets forth record-keeping requirements and prohibits the sale of feral swine and the commingling of breeding and feeding swine at the sale facility. KAR 9-10-57 maintains existing requirements for sheep and goats sold at a public livestock market or an occasional livestock sale, requires that those animals be identified with a form of official identification, and establishes record-keeping requirements related to those animals. KAR 9-10-58 clarifies the regulatory fees, inspection fees, and brand inspection fees charged by a livestock market operator to each consignor. And finally, KAR 9-10-59 maintains existing licensing fees consistent with KSA 47-1001E and existing application fees consistent with KSA 47-1001A. Again, Madam Chair, thank you for the opportunity to appear, and I'll now stand for any questions.
Thank you for that, Ms. Langworthy. Appreciate it. That's a lot of regulations to consider, and you did a good job covering them. Do we have any questions from the committee? Senator Francisco.
Thank you, Madam Chair, and thank you for being here. I do know that there was a change to the fees for brands made just this past session,
Yes, ma'am.
and just wanted to make sure that this separate brand inspection fee of $40 is consistent with that. And
that is a separate fee, which is covered under a different article of our regulations, which covers the registration and application to hold a brand. This is specifically for any inspection of those brands for animals going through the sale. So it should still be consistent with the updated law. You're welcome.
Next, we will hear from Representative Wassinger.
Thank you, Madam Chair. My concern is it sounds like there's a lot of testing and record keeping, et cetera. And while I see that there should be more costs, there's not even a reference as to how much more, say, one shot or vaccination would be. And I know you probably couldn't figure out the exact number, but I think you probably have a ballpark number of how many animals might have to be impacted, and kind of the record keeping. I don't even see an estimate of that, because I have to believe that it's going to cost some money somewhere. Is that a reasonable expectation?
It may be. A lot of the record keeping requirements are just carried over from the old regulations. One that I know of that is new is record keeping requirements for occasional livestock sale holders. So the new requirement is for them to collect certain information, which they're likely already collecting, but having them submit that information to our animal health commissioner so that it's usable in the event of an animal disease trace need. It is really difficult to quantify that, how many people that would implicate, or what a dollar amount that would implicate. But I can assure you that we've put into place online processes to streamline that and make it easier for our licensed public to do those things. But unfortunately, I'm not able to provide an exact number.
If I may, Madam Chair.
Yes.
I maybe I wasn't very clear when I said this, but it doesn't even give a ballpark. If it was just one person, how much would it be? How many, since this is not necessarily anything that's new, what's the ballpark of number of people? And we could even make the distinction ourselves, but I don't even see that.
I can look into that. It's such a unique situation by each person. Time would depend on, I guess, if they use a computer system, sophistication with computers, what kind of system they're using. But if either of my technical folks have any input on that, we'd be happy to look into it and get a better idea. It's just a really hard thing to nail down, just because of the uniqueness of the industry.
Well, I completely understand that, and I appreciate you're trying to look into it. Thank you very much.
Absolutely. Thank you.
Thank you. Committee, other questions? Representative Wagner.
Yeah, just a definitional question. You reference exotic animals. What is the official? What animals are considered exotic.
Yes, our K-State Wildcat, yes. We have the definition in 91041, so which is out of 47-1832. So we've got it defined in statute. Give me just a moment and I can get that for you. So, and then that's out of the CFR. I apologize. But we do have it narrowed down, but that's going to be.
I see there is a definition in statute. I just
Yes, sir.
wondered what it was. Right.
Absolutely.
Thank you. Committee, other questions? Senator Tyson.
Thank you, Madam Chairman. So I am curious as to what provoked all of these changes in rules and regs. I didn't see much that pertained to statute changes.
I was actually not here at the time. We've been working on these for a while, so I'll defer to Dr. Smith to answer that question.
Please introduce yourself and welcome to committee.
Thank you. Justin Smith. I serve as the Animal Health Commissioner for the state of Kansas. And thank you, Madam Chair and the committee. So a lot of these regulations have been put in place and have been there for longevity, and frankly, they were out of date. There's a lot of the regulations that we revoked dealing with such diseases as brucellosis and pseudorabies that are no longer a concern in the state of Kansas. We've eradicated those. We do have some provisions for brucellosis based off of the designated surveillance areas around the Yellowstone. But as far as the Kansas and any other state in the nation, we're all considered free of those diseases. So a lot of those specific regulations were out of date, overburdensome, and so we decided to revoke those. So a lot of the changes have been to refine them, make them more applicable to today's business practices and practices within the livestock market.
Go ahead.
Thank you, Madam Chairman. So you may think you're bringing them up to speed, but what you are doing is creating more bureaucracy, more burdensome on the I just don't understand why all of these changes, especially to this degree. And yeah, you talk to the associations, but I found through talking to actual producers, ranchers, sale barns, they don't always represent the little guy that's doing business. And this does create some burden for the average person. Thank you, Madam Chairman.
Thank you. Committee, other questions? Not seeing any, then go ahead and proceed. Thank you.
Thank you, Chair and committee.
I think we were going to talk about revocation of current rules and regulations.
I thought I'd covered it all together.
Okay, I'm sorry. I thought we were just doing the Article 10 public livestock markets that were being changed. And then, okay, so if we've covered those already and there are no further questions, then thank you very much for your testimony today.
Thank you.
Committee, that actually puts us back ahead of schedule. So next we will hear from Board of Examiners in Optometry and from Jan Murray, Executive Officer. Please introduce yourself and welcome to committee.
Good morning. I'm Jan Murray. I'm the Executive Officer of the Kansas Board of Optometry. And I've got two regs that we need to discuss. One of them.
Make sure your microphone is on. Is the
it's on. I'm probably just not talking into it
Okay,
close
great.
enough to it. Sorry.
Thank you.
So the first one is KAR 65-5-6. That's updating the continuing education reg. The major changes are it is reducing the amount of live hours from 16 to 12 per year and allowing 12 hours of online or non-live hours. It also, last time it was updated, they added CE could be attained through observing ophthalmic surgery, which in the past has always been non-live, or has always been live. They want to switch that now to non-live. And they also define live presentation has a continuing education program offered at at a set time during which the licensed optometrist is physically present in the same room or monitor as a presenter to ask questions and comments in real time. And that's something that was not defined. They've also updated some of the requirements and added if not a CE provider wanted to get approval for CE, what they needed to present to the board to get board approval for CE. And it had lots of comments that I think I forwarded to you so you could review too.
Thank you. Committee, any questions? Representative Sutton? Nope. Okay, great. We will give you a moment. Committee, not seeing any questions then, we will then thank Ms. Murray for her testimony unless
One
you
more.
Okay, I thought you had done both. I'm sorry, I've got a lot of communications happening. Thank you.
One more, and that's 65-5-15, and it's a new regulation, and it's basically has the reciprocal license active practice requirements for them to come in. It's very similar to the one that Board of Healing Arts passed previously. So, and then that's it.
Could you explain the reciprocal licenses a bit further?
Okay, so when a person applies for a reciprocal license, there are certain requirements that the board wants to make sure that they are actively practicing and they're not just in administration when they come over into Kansas. And so it says that they must work at least one day a week or 400 hours a year, and what all qualifies as a practice or active practice, like so. I'm not very prepared. I'm sorry. But it's basically they must demonstrate that they are in active practice to get a reciprocal license.
Is this kind of reciprocity requirements similar to what other states are doing for reciprocity?
I think so. And like I said, we kind of mirrored ours off what the Kansas Board of Healing Arts has.
And to make it the practice of optometry more available here in Kansas for Kansans. And okay, well, thank you. Committee, any questions? Yes, Representative Carmichael.
Thank you, Madam Chair. Hopefully a simple question. What is the time period required by KSA 65-1505 parent D parent? That's in the first paragraph of the reg. By submitting evidence showing the applicant has been engaged in direct patient care during the time period required.
I don't have that statute in front of me, but I'm almost positive it says that they must have a 3-year minimum in license, 3 years minimum in another state to qualify for reciprocity.
Thank you.
Thank you, Ms. Shelley. Can you confirm that that's correct about Chapter 65-1505D? Thank you. We'll check on that just to make sure. Thank you. And then we have a question from Representative Wagner.
Thank you, Madam Chair. Just sort of a conceptual question. The reciprocity arrangement that you have here, I mean, hasn't the legislature weighed in on occupational licensing? I mean, does that not affect this, or is this a totally separate item?
It should not at all. I mean, because we're doing the expedited licensure, and it just makes, it prevents somebody that's just an administrator coming in to get a license in the state and then haven't practiced in years, actually seen a patient in years. And so it's just to help prevent that from, licensing somebody that's maybe not, I don't know the word I'm looking for, but
I kind of my question of where I was going with it is, do each individual agency still have their own specific reciprocity statutes? I mean, I guess I mean, again, this might just be a novice question, but I thought sort of the bigger issue had been somewhat regulated, or do you know?
I really don't know. I'm assuming they would, but then I don't know. I just know what optometry does, and we do have the reciprocal statute.
I was kind of wondering the same thing, that whether the authority to grant reciprocity would rest with the board, or does it have to be something that's adopted by statute? If we could also get a question or an answer from the revisor on that as well. And I think we have an answer about our previous question about Chapter 65, 15, Section 1505. Ms. Moyer?
Thank you, Madam Chair. Jenna Moyer, Revisor Statutes Office. And the statute 65-1505, subsection D, would read that any applicant for reciprocal licensure may, in the board's discretion, be licensed and issued a license without examination if the applicant has been in active practice for at least the 3-year period immediately preceding the application for reciprocal licensure, in addition to the other requirements in the statute.
Thank you.
And
Go
I
ahead,
can
Ms. Moyer.
look into the other question, but generally speaking, when it comes to matters of specifically healthcare licensure and the reciprocity, that is generally, it would require statutory authorization for the legislature to accept licensees from another state being authorized to practice in this state, and that would usually come through either amending the specific statute or the adoption of compacts. You've seen a lot of compacts this year. You think like the social work compact allowing the interstate licensure of those. So it usually requires both the board to sort of bring forth that legislation and the legislature to adopt it.
So you say usually, are we outside the usual with this, or does this fall under the authority we just heard in 65-1505 subsection D? I'm thinking it does, because this particular proposed regulation has been approved through the approval process by the Department of Administration, the Attorney General, as well as the Secretary of State. But we need to do our due diligence here as well and make sure before we act on it. So.
Thank you, Madam Chair. The Board of Examiners in Optometry is authorized to adopt rules and regulations for the administration of the optometry law, which shall not be inconsistent with the provisions of the optometry law. It would be common for a board to adopt regulations governing how that reciprocity would work, such as this regulation.
Thank you for clearing that up. Do we have any other questions? Representative Sutton and then Representative Penn.
Thank you, Madam Chair. I was going to go in exactly that direction. When we passed the reciprocity bill, we did not get granular enough to explain every detail for every healthcare worker in every industry. That was left up to the agencies to do so, so long as that reciprocity was possible. You know, we mandated that it was possible. They just had to do the easy task of figuring out what that looked like. So, which maybe is a failure of legislation, in my opinion, something that we should be more cognizant of in the future. But I think this is very well within what our reciprocity law had to say. Thank you, Madam Chair.
Thank you for that. And hearing from the revisor that in statute, it is authorized for the board to act in this proposed manner. It's just helpful to make sure that we reference the legislature's enactment of law before the board takes action. And it sounds like we do have that in place now. Whether the legislature needs to get more granular as suggested, that's something that I'm sure the legislature will be taking a look at. Representative Penn.
Thank you, Madam Chair, and thank you, Representative Sutton, for that explanation. I wanted to go back, if we could, to the continuing education piece, ma'am, and thank you for being here today. I'm on the second page that we have. You talk about the new requirement. There's a lot of stricken language in paragraph. What's this? D. It's the new paragraph C, I guess. And it says on C2, educational meetings of, and they struck Kansas State Optometric Association and added associations. And it's kind of in line with what we're saying on it, and it may have already been answered. But I guess my bigger question is, if you were going to be changing what the requirements are for their continuing education, is there a fiscal impact across, as we're discussing the reciprocity laws? Does that allow for other states? Because they struck out Kansas and they put associations. What does that mean exactly?
So the way it was originally intended is that if Kansas State Optometric Association put on a CE, then it would automatically be approved. But there are other states that people go to that weren't listed. And so we just thought if we removed Kansas and made it all encompassing to the other state associations, that it would be less confusing and more, allowing people to go to other states associations and not have to worry if it was COPE approved, which is the approval system. Yeah.
Madam Chair, if I may follow on, is there a fiscal impact? Do those other associations in other states, do they charge more for to attend, or is that something that a burden?
I really don't know.
Okay.
But I know I get lots of phone calls I'm going to the Texas association meeting. Well, can I count that towards my TCE? And that's, Texas, Florida, people like to travel around, especially ones that have got other licenses in other states. So that was the only thing, was to clean that up so they could go anywhere they wanted, as long as it was a state association meeting, that they could still get credit.
I don't want to make a mountain out of a molehill. Just want to make sure that if our folks are going to do that, the fiscal impact is not something that's hurting our folks' pockets because they're in joining with other states. That's all. Thank you, Madam Chair.
Thank you. Committee, other questions? Not seeing any, then I think that covers your agenda today, but thank you for appearing. Appreciate it.
Thank you.
Committee, next we will hear from the State Board of Pharmacy, and I have down Bradford DeYoung, regulations attorney, but I think did Representative Wassinger, did you have your hand up or no?
Yes, Madam Chair, I did.
Okay, go ahead.
I would publicly like to ask the Board of Pharmacy to postpone implementation of these regulations, as they've already done for a year. Legislative intent was that they take it out of a bill that was produced last year, and which they did, and now they're back putting it in. I have contacted the Attorney General's office to verify and see if they were aware of legislative intent in this instance. And so I would publicly ask the board to postpone implementation. I have a couple other questions if they want to answer some other questions or give them some idea of what I'm thinking about.
Thank you, Representative. I think we will go ahead and listen to the presentation and then ask questions. And if there are other concerns you have, you can raise them at that time, or did you want to raise them now?
We've seen these regulations before. They've been around. And we've had problems with them before, and we've written letters. They have gone back to try to get specifically 68-23-2. They have tried to get, and apparently did get, information from the Attorney General's office to be able to put 68-23-2, some of the regulations in that. And I just need more guidance from the Attorney General's office and have not received any phone calls back. So.
Well, let's go ahead and hear the content of the proposed revocation and the new Article 23, and we'll see where we are at that time. Thank you. Go ahead, please introduce yourself and welcome to committee.
Good morning. My name is Bradford DeYoung, and I am a regulations attorney with the Kansas Board of Pharmacy. And on behalf of the Kansas Board of Pharmacy, I'm glad that I have the opportunity to speak to you about these regulations. And as has already been discussed, there are more or less two different sets of regulations that we'll be working with here today. There is the first batch, which includes 6825, 225, 714, 718, and 191, which cover a smattering of topics throughout our regulations. And then, as Representative Wassinger mentioned, there is the second batch, which deals with telepharmacy, and that's 23.1 through 23.6. If you don't mind, I'd like to start with the first set so we can make sure they get their time in the sun before we begin to delve into 23.1 through 6.
Yes, let's go ahead and hold off on new Article 23, and we'll have your presentation on the other. Thank you.
All right. Well, without much ado, our first regulation is probably the easiest we'll be dealing with today because it's a revocation. 6825 was revoked because the content of 6825 was moved into a separate regulation to consolidate all of the pharmacists in charge, or PICs, responsibilities into one regulation, and that is 6819, which I believe was passed last year. Do I have any questions about 6825, the revocation? Seeing none, I'll move. Oh, sorry.
I'm sorry. There were some other communications happening. So thank you for speaking up, Representative Carmichael. Please go ahead.
Thank you, and I'm sorry, I just didn't want him to move on through and we not get back to my question. First, I missed your name, sir. What is it?
My name is Bradford DeYoung.
Bradford Young?
DeYoung.
Bradford
Young.
Bradford DeYoung. And you are the regulations attorney for the State Board of Pharmacy, is that correct?
Yes.
That's a position in state government that I'm not familiar with. Can you tell me, is that a full-time job?
It is a full-time job.
And what do you do on a full-time basis for the State Board of Pharmacy?
My primary goal and job description has me updating all of our regulations, specifically after, and I believe I'll misremember the exact bill number, but it was 22 HB 2087, I want to say, which I believe you'll be covering some of the reports you'll be dealing with that bill today. I see some of the new regulation reports. My job is to update our regulations, go through our regulations, and ensure that they are up to date, that we do not have any incorrect language, which I'll touch upon later, as well as ensuring that when we do finally get to our chance to do a report, which will be next year, that I will be the one primarily responsible for that. As well as those duties, I also assist the executive secretary in all matters related to regulations and anything that she needs me to do for those regulations or require somewhat of a legal eye.
How many lawyers are there at the State Board of Pharmacy?
Well, I believe there are just two. It is myself and the executive secretary.
And how long has this position existed at the State Board of Pharmacy as a full-time FTE who does nothing but handles regulations?
I believe I started in August of 22, if I'm recalling correctly.
So have you been in this position the entire time?
Yes.
So for nearly 2 years, we've had half the legal staff at the State Board of Pharmacy doing nothing but updating regulations, supposedly or apparently in response to a statute that we passed. Is that correct?
I would hesitate to say it is only due to the statute that the legislative body passed. I would say that, as obviously this committee is well aware, regulations do need to be updated from time to time as we ensure that language is continuously kept up with current standards. And so this job previously fell to other members of the staff, and quite frankly, they just didn't have the amount of time necessary all the time to work through these regulations. So I was onboarded to make sure that I was the one who primarily dealt with this. That includes working with the D of A, working with the AG, working with our inspectors, some of who are with us today, to update the regulations so that way we are within, or that we are continuously maintaining optimal regulations for the practice of pharmacy.
So thus far, you've spent approximately 4,000 hours doing nothing but updating regulations at the Board of Pharmacy, and I take it this package is the work product of that roughly 4,000 hours of professional time. Is that right?
I would say that this packet represents one part of the regulations that I have worked upon. We have other regulations in the works, including adopting USP, which has taken a large bulk of my time.
What is USP?
USP is the United States Pharmacopoeia. This was a set of, let me rephrase that. United States Pharmacopoeia, they're not regulations per se, they are standards set by the committee of USP. The federal
USP?
USP is the United States Pharmacopoeia. It's a organization that promulgates the best standards for a lot of aspects of pharmacy. And in this particular case, I've been working on sterile and non-sterile compounding, as well as hazardous drugs and some nuclear drugs.
I interrupted your answer to inquire as to what USP meant. Did you have any further answer for us this morning?
I'm afraid I don't understand your question then.
And never mind. I'll express my concerns when it comes time for comment. Thank you.
Thank you, Representative, and thank you for your answers. And go ahead regarding the revocations.
The regulation 2.5 is being revoked, and I believe that was the where I ended. I think we're ready to move on to 2.25, which is a new regulation.
I'm sorry, so 68-2-25?
Yeah, 68-2-25, which is a new regulation.
Okay, go ahead.
This regulation deals with the non-controlled substance counterparts to 68-2018, which is the information concerning prescriptions. What this regulation primarily handles is requiring that non-controlled substances in the prescriptions contain certain information, including things like the name of the prescriber, the patient name, the drug name, the quantity prescribed, and I think as we can all agree, importantly, the directions for use. This regulation also directs pharmacists to document any changes, additions, or corrections or updates made to the prescription on the prescription, which I might note can be either the paper prescription or an electronic prescription. That is what 68-2-25 does. And as I mentioned, this is a sister regulation to the controlled substance regulation.
So there's a lot in this new regulation, but are these items not already currently the practice of pharmacists? For instance, containing the following information at the minimum: the date the prescription is issued, the name of the prescriber, the signature of the prescriber. Those aren't already required?
For non-controlled substances, I believe that is correct. We are looking for the correct word. It's not unifying, but making sure that all pharmacies across Kansas ensure that this information is included in the prescription. Otherwise, sometimes we have situations where this information is missing, and then that can result in, for example, once again, returning back to the quantity of the drug prescribed. That can result in issues if a patient was prescribed the wrong quantity because that information was missing. So we're doing this for patient safety purposes.
Have there been instances where patient safety has been negatively impacted without these regulations?
I don't have that information in front of me today. I'd be happy to inquire and get it back to the committee.
Well, what was the impetus then for, I think you said, just to make it uniform with the controlled substance? For those following along, could you give some examples of prescriptions for non-controlled substances?
Sorry, repeat that one more time, please.
Could you give an example of a non-controlled substance?
A non-controlled substance. Do you mind if I inquire with my
Nope, go
pharmacist
ahead.
inspectors?
Yes, go ahead.
So I think probably the most common non-controlleds are going to be things like blood pressure medication, antibiotics, medications of those sorts that are not under the controlled substance list, which this legislative body just updated this year.
Those sound like pretty routine prescriptions. Has there been any investigation by the team of regulations attorneys at the Board of Pharmacy about how much more manpower this will take or hours by the prescriber to implement this?
There has been no independent investigation. What happens is that for each of our regulations, before they ever make it to the administrative process, we inquire with our stakeholders. So, stakeholders being any pharmacy, pharmacist, person of interest who wants to provide feedback about these regulations. We ask if they have any thoughts or feedback for us ahead of time before we even move this through the regulatory process. And at that time, I don't believe we received any feedback regarding negativity towards the amount of hours or man hours or extra money that this regulation would cost.
Thank you for letting the committee know that information. Any other questions before we proceed? Not seeing any. Go ahead then with KAR 68-7-14.
All right. This will be an amended regulation. This regulation was last touched in 2009. And this regulation primarily governs what information the prescription label must include. So previously in 225, we dealt with the prescription itself. Now we are dealing with the prescription label. This regulation also cleans up language regarding who will be allowed to label or relabel drugs or devices originally dispensed from their registered location. I think the easiest way I can explain this regulation is primarily a cleanup of language as well as updating the information required for the label itself. And I would direct your attention to A7, which discusses the beyond use date of the drug or device dispensed.
Go ahead. I don't see any questions.
Moving along to 68.7.18. This regulation deals with health departments, private not-for-profit family planning clinics, federally qualified healthcare centers, and indigent healthcare clinics. This is an amended regulation, and this regulation was last touched in 2000, which I might add was 24 years ago. This regulation, one of the things we are primarily doing this regulation is updating it to include federally qualified healthcare centers and indigent healthcare clinics. The statutory authority for this regulation actually includes FQHCs, federally qualified healthcare centers, and indigent healthcare clinics, but the regulation did not. I don't know if that was just because the statute was updated after the regulation was originally written, or if it was missed for whatever reason. This was 24 years ago, so I'm a little bit unfortunately was not there for that time. This regulation also creates a system for indigent healthcare clinics and federally qualified healthcare centers to store, supply, as well as provisions for record keeping, because they act very similar when they dispense and supply medication as a not-for-profit family planning clinic. Along with this regulation changes, we streamline the language for this regulation, removing clunky and confusing language, as well as bringing language to the modern era. I mentioned earlier that I would come back to a point. So, for example, a lot of times in this regulation and other regulations throughout our regulatory body, we use the term physician. Physician is out of date at this time. It is because a physician is not the only individual who is allowed to prescribe drugs. That also falls under, I believe, so sorry, it's a type of nursing. I just blanked on the APRN. Thank you. Our APRNs also have the ability to prescribe drugs in certain situations. So if we just say physician, that causes confusion, which may cause doubt for our APRNs and other individuals who have been authorized by Kansas law to prescribe medication. So we've updated that to prescribers, not just physicians. I think that's kind of a best example of clunky, outdated language that needs to be updated for the current practice of pharmacy. This regulation will also clarify the approved drugs that may be stored and supplied by federally qualified healthcare centers, and it updates the policies and procedures for supervision, storage, documentation, drug recall, and record keeping, as well as requiring these facilities mentioned to maintain a searchable database for critical drug and patient information. I would note that that does not mean they have to be an electronic database. It could be a old school paper system. It just has to be searchable. And that more or less covers the changes in 68.718. Do I have any questions?
I see that the regulation changes all references to distribution or distribute to supply and, well, to supplied. Is that following other law, or what's the difference between the two?
So once again, this is just like the prescriber situation where we have updated the language to more closely match the intent behind the legislative body. Distribution has its own connotation behind it. So we are updating it to supply because it's not a distribution moment, it's a supplying moment. Would you like more clarification on that, or does that answer your question?
No, I do realize that distribution has certain definition in law as well, which is different than supply. And so thank you for that answer. Are there other questions? Not seeing any, then go ahead and proceed with KAR 68-19-1.
All right. 68.19.1 is the minimum program requirements, which the title alone doesn't say much. And this regulation primarily deals with CQI, or continuous quality improvement. Continuous quality improvement is, as the name suggests, the goal of pharmacies to continuously improve. And we see this primarily in instances where there may be a time where for example, let's say you have a prescription and you go to your pharmacy, you get that prescription filled, you've done it 100 times before, and you go home and you look at that bottle that has the prescription in it, and you see all the little correct white pills that you've always seen in that prescription, but you notice one yellow pill in there. Something's wrong. So you take it back to your pharmacy and say, hey, there's a yellow pill in here. This is not my prescription. That's what we call an incident. So this is the moment in time where the pharmacy needs to be asking themselves, how did this happen? How can we ensure that this doesn't happen again? And what can we do to make sure it doesn't happen again? And that's where we get into CQI, continuous quality improvement. So in this particular case, you take it back to the pharmacy. They are now aware of this issue, this incident, and they will need to, or rather the pharmacist in charge or their designee will need to go through and interview each person who was involved in this incident, go ahead and do a root cause analysis. So how did this happen, right? What is the root cause for this issue? Where did we go wrong? Create a corrective action plan. So how can we fix this in the future? And then once about every 2 months, they will disseminate that information to all of the pharmacy employees to make sure that they are all aware of what happened, the corrective action plans going forward, and then a look back period to see how well did those corrective actions plans actually work, or if there was a moment where the corrective action plan isn't working. So this is what CQI is, and CQI has a direct CQI was left to the Kansas Board of Pharmacy by the Kansas Legislature, and that is 65-1695. The other final note about CQI that this body may be interested in is that there is an exemption for patient safety organizations, or PSOs for short. Patient safety organizations are organizations that are defined federally, and they are not a federal body, but they work with, or they're certified by the federal government, and they have an express purpose of, as the name might suggest, patient safety. In that case, there is information that becomes proprietary that we couldn't even subpoena if we wanted due to federal law, that we won't touch, that we can't touch. And so we provide an exemption for that particular area.
Thank you. Committee questions? Not seeing any, then I'm going to, oh, sorry, Representative Penn.
Thank you, Madam Chair. And thank you for being here today, sir. How are you?
I'm sorry.
How are you?
I'm doing good. I was not expecting that.
There we go.
Doing good. Thank you. How about yourself?
I can tell you're not expecting it. I can tell. We're a fun-loving crew and a very generous body, and I like to see your smile because I want to tell you have a nice suit on. I haven't seen double breast in a while, but you look cleaner than the health board or the pharmacy board. It's just a quick question. Going back, as a matter of fact, to the previous one.
Yes.
KAR 68-7-18.
Yes.
Well, Madam Chair, I have more of a general gripe bone to pick in that, to the distinguished representative from Wichita's point, this gentleman has spent 2 years, combing through regs, finding where the fat is, getting ready to trim it. And as we're going to hear today from what I see in this packet, you found one. But you propose, at least that you're going over right now, 4 amendments, which is additional regulation, which is additional cost, which is additional burden. And we're going to go through, at the end of this, it's going to be 11 total. So that ratio is off to me, and I don't understand why we don't have more that we're going to be rescinding or revoking if you've been looking at it for 2 years. So that's the first piece. But then going back, as I said, to KER 68-7-18, where you say in here, sir, that I'm just looking at the summary that I have on the first page, you put in the FQHCs and that they do the store and supply of the controlled substances. They're requiring the pharmacists in charge to ensure that the facilities maintain and implement policies and procedures for drugs, requiring those facilities to maintain records and searchable databases. Final sentence right there. The board anticipates that the proposed amendments will have minor to no economic impact. I find that farcical, hard to believe, because if you're going to be storing drugs, and I know where the FQHC is down in at least a couple of them, actually, as a matter of fact, in Wichita and some other places around the states, for them to be compliant with the new regulation that you want to add on, there's got to be some economic impact because folks are going to have to be in compliance. They're going to have to get storage. They're going to have to get security. There's got to be a lot going in. Are you being truthful with this?
Am I being truthful with you? Yes. And I'll explain how this is, as you say, truthful. So one, I think it's important to note that we are a permissive body of regulations, which means that if we don't say you can do it, there's a good chance that you probably can't. So for FQHCs and indigent healthcare clinics, what they can do, federally speaking, obviously is a different game than what we're doing here today. But for Kansas, if they want to supply and store these drugs, we have to let them into the fold. So really what we're doing is actually expanding this to say, yes, you can do so because you operate very similarly to a not-for-profit family planning clinic. So honestly, I'm hoping that this will actually be a boon to Kansas. But at the same time, our EISs don't exactly allow us to describe a lot of the benefits to it versus the offset. We don't really have the chance to offset the balance. So we're hoping that the allowance of these FQHCs and indigent healthcare clinics will be a benefit to Kansas, not a net drain.
Well, Madam Chair, if I may, and I don't want to be contentious with you, but I did 20 in the Army, and we had this one general, he had a great, great book out. General Sullivan said, "Hope is not a method." So that does not give me any solace about this final sentence. The board anticipates, you hope. Those are very fluffy, ambiguous terms that the proposed amendments will have minor to no economic impact. I'm thinking that those indigent health clinics and those FQHCs, they're going to have an economic impact in order to be compliant with this. They're going to have to hire on personnel to make sure that they're jumping through all the hoops, both, as you say, federally, which is not the bailiwick of this particular body because we're in the state of Kansas. But for you to be permissive and put this down as a regulation, this isn't saying that, hey, you guys can do this. You're putting it, you're asking us to put this on the book and make sure that they are compliant with it. So that's a regulation or an amendment to a regulation that you're demanding that they comply with. So they don't get to hope to say pound sand. They have to comply. And in order to do that by the regulation that you're proposing, they're going to have an economic impact. So I ask you again, are you being truthful with us?
Yes.
I doubt that. Thank you, Madam Chair.
Thank you. I have follow-up questions to that, looking again at 68-718. Had you testified earlier that this particular regulation hadn't been looked at in 20 years? That this was from last looked at in 2000?
As I have it in the history section, it was amended April 28th of 2000.
2000. So are you saying that for 20 years then, that federally qualified health centers and indigent healthcare clinics, which the regulation proposes to add in to this regulations, that they haven't been distributing or supplying and controlling drugs because this, which you said are permissive regulations, wasn't in place?
If you don't mind, I'd like to consult one last time to make sure that I'm being accurate on that.
Sure.
Okay. So I want to make sure that we're clear. Yes, the federal government already controls a lot of this. However, the federal government limits what they can do in Kansas or rather in the United States as a whole. This would be expanding what they are allowed to do. So the federal government only authorizes up to X, but it doesn't necessarily say they can't go past that. It just says they're only authorized up to X, and that's more of a state question, I believe. At which point in time, we are now expanding what they're allowed to do in Kansas.
So to narrow my question a little bit, without the proposed change to this regulation to add in the permission, as you said, and the allowance, as you said, for federally qualified health centers and indigent healthcare clinics to distribute, supply drugs provided by the health department, are you saying that for the last 20 years, the federally qualified health centers and indigent healthcare clinics in Kansas have been distributing, supplying drugs with no guidance by the state of Kansas without this regulation?
I would say that that is not necessarily correct. I would say, if I may, that the federally qualified healthcare centers and indigent healthcare clinics have been, pursuant to federal law, doing smaller, we'll just say smaller amounts of this controlling drugs, we'll just say, and that this would be allowing them a greater latitude for the supply and control of drugs in Kansas. I don't have the federal CFR in front of me, so I can't go line by line with it and discuss the differences.
Have there been problems in the last 20 years? How federally qualified health centers have been operating and indigent healthcare clinics have regarding the supply and control of drugs?
I'm not aware of them having issues. I may not know that information off the top of my head, and I'm sure I can supply that to you after. But what I can say is that we are then, I think more importantly, is that we are returning back to what our statutory authority says. And the statute says FQHCs and indigent healthcare clinics should be as part of this regulation. And so we are returning back to the statutory and making sure that we are closely following the statutory authority.
When you say closely following the statutory authority, do you mean the statutory authority that was enacted in 2000?
I don't recall the exact year when the statute was enacted. I can only say that as it currently stands today, we are not quite hitting the FQHCs and IHCs today.
Without this proposed regulation, have the federally qualified health centers and indigent healthcare clinics been supplying and controlling drugs illegally?
No, not illegally, but they've been doing so in a limited capacity.
Committee, are there other questions? Not seeing any then. Are you through with your presentation on KAR 68-19-1?
Yes.
Okay, then I'm going to recognize Representative Wassinger, who I think wanted to speak.
Thank you, Madam Chair. Once again, I'm going to ask that the Board of Pharmacy postpone implementation of 68-23 -2 in particular, because there is a disagreement as to whether or not they have the authority to do that, since the legislative intent through a bill last year, it was made very clear that legislative intent was that they not be able to limit the mileage and the number of people and residents in a city. I just, I've called the Attorney General's office. I am trying to get further information, and so I request that they postpone implementation, since they've waited over a year to do this. And I will just ask that they postpone all of 68-23 until we can get further messages from the Attorney General's office and have them look at it again.
Thank you, Representative. Is that a motion to table looking at the proposed new Article 23 regulations?
Not necessarily a motion to table. I would like to table it, but I'm asking them to postpone implementation, since they do know that this has been a contentious item. I have talked to the Board of Pharmacy yesterday, in particular Alexandra, last night. It was a public holiday, so I apologize for bothering her on that. The issues that I have with this is, number one, it was taken out of a statute, because not only did the Attorney General say it wasn't allowed at that time, as well as legislative intent that we didn't want them to do it, but our whole telepharmacy bill was to increase access to pharmacies, and this is not increasing access. As well as, I don't think they've done any research to see why they should be doing these requirements. and are other states doing this? Are other boards doing this? I think there's a lot of questions, and I would like to ask them to delay it so that I can speak to the Attorney General's office once again.
Thank you. We have a second for the motion. I think Representative Sutton wanted to speak to that.
Right. Well, I wanted to clarify the motion first off.
Yes, I do too. Is it a motion to table, or what is the motion before us, Representative Wassinger?
I'm asking them to postpone implementation of this. I would also like to move to table it, but I would rather that they postpone implementation voluntarily before I push them into doing this involuntarily.
I'll
Go ahead,
second the involuntary motion.
So the motion before us is a motion to request the Board of Pharmacy not proceed with the implementation of new Article 23. Is that the motion before us? Do I have that correct?
Yes, ma'am.
Thank you. Is there discussion about that? Representative Carmichael. I'm sorry. Ms. Moyer, did you want to speak to that first?
Thank you,
Make sure
Madam
we have it
Chair.
correct.
I was just going to explain what the repercussions of passing this motion would be per the statute.
Thank you.
The statute that governs the JCAR is KSA 77436, subsection D, requires that all proposed rules and regulations be reviewed by the Joint Committee on Administrative Rules and Regulations during the public comment period required by another statute, that the committee can introduce legislation as it deems necessary in performing its functions of reviewing administrative rules and regulations. There's not a procedural mechanism that I'm aware of, either in the statute or the joint rules, that would allow a joint committee to prohibit an agency from proceeding with its regulations, except for passing legislation.
Thank
Madam
you
Chair.
for that clarification. Yes, Representative Wassinger.
I'm asking them to postpone it. And they started this over a year ago, so I don't think that there is a rush for them to do that, as well as asking them to allow me time to speak with the Attorney General's office in length to make sure that this is not something that the Board of Pharmacy has taken upon themselves to pass legislation through regulation, which we know is a regular opportunity for all of these agencies. I don't think this is against regulation for JCAR. I am asking for them to voluntarily postpone this.
Thank you for that clarification. And I think procedurally what I'm hearing from the reviser is that procedure in this committee would be a motion, or just, I don't think it would require a motion. I think the chair has authority to determine that we are not going to review any particular regulation. Do I have that correct? Or does it require a motion?
Thank you, Madam Chair. The statute requires that the that JCAR review regulations during the public comment period. If JCAR does not review a regulation during the public comment period, that does not mean a regulation cannot go forward. If that makes sense. So it is the committee's obligation to hear the regulations. If the committee chooses not to hear the regulation, you would be in violation of the statute. I don't know what the exact ramifications of that would be, but it would not be that the agency could not proceed with adopting the regulation.
Which is why, Madam Chair, I am asking them to voluntarily do it until we can talk to the Attorney General's office. And this may mean that we are going to need another meeting before their public hearing in July, but I think it is professional courtesy when there is a great deal of consternation on what they are doing to allow us some more time to investigate what's going on.
Thank you. And um, my understanding of the situation about the request for additional time is that the proposed regulations in new Article 23 um, would regulate two topics that were stricken from the 2021 telepharmacy bill, HB 2280. Those topics were stricken by the legislature, and that though stricken from the statute, the proposed regulations are nonetheless found in new Article 23. Is that kind of what you're asking for further investigation on?
Yes, ma'am.
Thank you. Is committee clear about what the issue about the proposed new Article 23 is? And if not, please ask.
Madam Chair.
Yes, Representative Carmichael, and then Senator Fausto.
Thank you, Madam Chair. First, I want to make sure that we obtained a second for the final phrasing of the motion that's before us.
We did. We had a second from Representative Sutton. Thank you.
Want to confirm that. To attempt to address this succinctly and on the merits. It looks to me like, from what I've heard from the chair, that in 2021 we passed a bill apparently that deleted some provisions, or did not include, I guess, perhaps some provisions that appear to be in the regulation in question. And I don't know that to be the case. I haven't looked at that 2021 bill probably since 2021. But I do know that in November of 2023, after presumably the effective date of that bill and as a result of law, I assume, that our Attorney General found that this regulation does in fact comply with the law. That's one of the prerequisites for the Attorney General to approve a regulation. The Attorney General does not have to agree with the policy. Rather, the Attorney General looks, one, to see if this regulation is within the existing statutory authority. Two, whether or not the regulation conflicts with statutory authority. And three, whether the proposed regulation conflicts with established case law. It looks to me, whether we like what the Attorney General said in 2022 after the enactment of a 2021 law, that's the authority. It's from the Attorney General. The Attorney General has, absent a lawsuit, the authority to disapprove a regulation if it violates the law. So it appears to me the Attorney General made that determination 2 years ago, nearly. The second thing I would observe is that there has been, at least on one prior occasion that I can think of, where the Attorney General's office has retracted a prior approval of a regulation. I don't know whether that's legally effective or not, hasn't been challenged, but my guess is if the representative, the vice chair actually, can demonstrate to the Attorney General that this proposed regulation is contrary to law, that the Attorney General won't hesitate to revoke the approval. And that stops it. As was observed by our revisor, we can't stop it absent legislation. And I thought about this over the past several years. We've talked about what the authority of this committee is. We've had constitutional amendments that arguably could affect the authority. I think we're going to have a new statute going into effect, which may relate to these things. But I don't think any of the current constitutional or statutory law allows us to stop a regulation absent introducing legislation and passing a bill and the governor signing it. So we can ask, which is what this motion is, that they delay the implementation pending further work by the committee or work by the Attorney General. But I don't think that for those of you who, as much as some would like to be able to do this, I think the effect of us saying we table regulation is that we just take ourselves out of the mix. We give up our right to even comment because we just tabled it and the agency just goes ahead and adopts it. So I'm not going to vote in favor of this motion because 2 years ago, the Attorney General approved this, and I haven't seen anything from the Attorney General to the contrary. But I do share the representative's concerns. Thank you.
Thank you. And one point of clarification, it wasn't approved nearly 2 years ago. It was 7 months ago. But
I'm sorry, I don't even know what year it is, Madam Chair. It's been a long day, and I missed 2 exits on the highway this morning, and I'm on my first cup of coffee. Thank you.
you're lucky to be here then, I suppose. So, yeah. Senator Faust-Godot and then Senator Tyson.
I'm sorry, I'm unmuted now. Thank you, Madam Chair. To Representative Wassinger's request is what I hear, not actually a motion, but a courtesy request. So if I may ask her for clarification of when she hears back from the Attorney General or others that she's seeking information and clarification from, would she want just an email or for all of us to be emailed of her findings and then move forward? Or would this Joint Committee on Rules and Regs have to meet again to hear the findings of her concern? If she would clarify how we would move forward on her courtesy request.
Go ahead, Representative Wassinger.
Thank you, Madam Chair. Senator, this request, should I not get what I believe I will get from the Attorney General's office, they can go ahead, if we don't meet again, they can go ahead and implement the regulation. The request is to ask them to postpone it and give us more time. As I said, I contacted the Attorney General's office and I have not gotten a return phone call. So I would be more than happy to send any information I get to the legislative research and they can respond to everyone. I'm more than happy to keep everyone apprised as to where I am in this process.
Thank you. Next we have
Madam
yes.
Chair, so just for clarification, it's not to table and it's not actually a motion. So how will we move forward from the chair's recommendation? Thank you.
Thank you. And the chair's recommendation, I don't have a motion or anything that I have made, but other than to clarify with the revisor, is the motion in order or is it something that we make comment on in the report that the committee is going to generate? And I think we have, before we turn to the revisor, let's hear from Representative Sutton.
Thank you, Madam Chair. What this motion, and it is a motion, what this motion would do would be to make this a committee request to delay, not an individual request to delay. That would be the difference.
Thank you. Yes, Ms. Moyer, and then back to Senator Faust-Godot.
And I will just clarify that the chair has a wide latitude in what motions are in order and out of order, especially given that this is a joint committee meeting. That if the chair feels that it's in order, it's her right as the chairperson to run the meeting as she sees fit, including accepting or not accepting motions.
Thank you. And with the discussion we've had, clearly the chair deems that the motion is in order. Senator Faust-Godot.
Appreciate that clarification. Thank you, Madam Chair.
Thank you. And before we turn to other questions, Representative Wassinger, did you want to respond to the further discussion we've had?
Yes, thank you, Madam Chair. We have sent a letter to the governor. We have addressed this many times. And I think at this point, the response we'd also need a response from the Board of Pharmacy.
Thank you. And next we will hear from Senator Tyson.
Thank you, Madam Chairman. Back to some of the comments Representative Carmichael made. I am curious. It seems like a little bit of conflicting information here that these rules and regs appear to be overstepping statute authority. Not that we're just asking for a look at that because of the overstep, the overreach, not because of anything else. Wouldn't that be correct? Or is
I'm sorry, was that a question to the representative or?
just in general? I understand he said that we don't have any authority. I absolutely agree with him on that. I just am trying to clarify. This isn't, it, I don't know. We have these agencies and departments that overreach. They don't have the authority. We pulled the authority back in statute. And so why would we need another statute to say you don't have the authority to do this? Is that correct?
That would be a question for the revisor. And to help with that question, where in statute is the authority for the Board of Pharmacy to regulate regarding telepharmacy?
Thank you, Madam Chair. You'll see the authority memo is uploaded on the S drive in our committee documents, and that relevant statute is KSA 6516, 130, and it lays out. I'm not going to read the whole thing, but the board shall adopt rules and regulations necessary to administer specific additional criteria for managing a pharmacy and telepharmacy outlet under this section, including but not limited to, and there are 9 different things that are listed, the aspects of a telepharmacy that could be regulated.
So yes, Senator Tyson.
Madam Chairman, so it's back on the legislature again. I think many times when we pass these bills, the majority of the body doesn't realize that we are turning over absolute authority and the power of the law. And so, yes, the constitutional amendment did not pass, but I think if a majority of people understood what it was trying to do, it wasn't trying to give us any more authority than we have. But we need to quit relinquishing our authority to the administration because this is a prime example of them going rogue. Thank you, Madam Chairman.
I agree. We certainly need to reform the process of how the state of Kansas implements rules and regulations. A comment that I wrote down from our conferee regarding discussion of supply and distribution and control of drugs at federally qualified health centers and indigent healthcare clinics said that the Board of Pharmacy, and I'm quoting, is hoping that the new regulation is a boon to Kansas and the allowance of these new regulations will be a benefit and not a net drain. That to me sounds like a policy determination, and those policy determinations should be determined by the legislature of the state of Kansas, by your elected officials who are responsible and accountable to Kansans. And when we have any department or any agency making policy decisions that should be within the legislature, that is a concern. Constitutionally, it should rest with the legislature. And it has been the work of this past session to bring some reform to that issue, and that reform needs some additional work because it did not advance to become law. But with that, then I think Representative Sutton wanted to speak, and then Representative Penn.
Excellent. Thank you, Madam Chair. I just want to go over the laundry list of what I'm putting together for next session. Obviously, we're going to get an opportunity to vote on, but not limited to, showing up in the enabling statute there. I think also it's going to be appropriate that we review the makeup of the Board of Pharmacy. So I'll also be introducing that. We'll have a great opportunity to take multiple bites at this apple, should they choose to proceed with it. Thank you, Madam Chair.
Appreciate that. And I would think that would be a needed reform, is that we talked earlier about, not getting into the granular as the legislature, but clearly we need to be more cognizant of when we put into statute, but not limited to, that's pretty broad and pretty vague. Representative Sutton.
Exactly. Thank you for giving me another chance here. My issue with this isn't just overstepping the authority provided by the legislation. This is an access to care issue. And the way these lines are drawn, there are very small areas of Kansas that are actually eligible to be covered. There are a lot of people who are not. And that's not the way we wanted the legislation to work for telemedicine. That's exactly the opposite, as a matter of fact. So it's not just the overstepping, it's also the adverse effect on the legislation itself. So thank you, Madam Chair.
When they overstep, then in this instance, the intent of the legislature was to provide more access with telepharmacy, and the regulation seems to restrict it. So, kind of a double-edged issue there. But yes, Representative Penn and then Senator Tyson.
Thank you, Madam Chair. I'll be brief, and I really appreciate the conversation. The good representative from Wichita. I appreciate your analysis as well as the senator from Wichita. I wanted to make sure that I made a comment about the time frame on this particular motion, the committee motion that we would do. I think the vice chair was stating that, hey, if she didn't get word back from the different key stakeholders, then they could proceed. I would comment that it doesn't happen automatically, because we don't own the schedules of those other entities, and they have their own priorities, and we have to be cognizant of that. So I would recommend to the committee that this, if this motion passes, and that the agency is compliant with it, that we wait until we get back all of the due diligence and data responses and everything, and then schedule it on our next regular meeting that comes after that point, versus it taking automatic publication. I'm definitely with my chair over here for the insurance committee when we're talking about the access to healthcare and the access or the elimination of it because of how we're looking at regulations. The other thing that I would say is that we stand before the people and put our names on the ballot. We're not nameless. We're not faceless. We're not the the amorphous bureaucrats. So if that is indeed that they want to do, according to constitutional delineation of power, is do the things that are necessary and proper to enact legislation, please put your names on the ballot, stand for election. Thank you.
Thank you, Representative. And then Senator Tyson.
Thank you, Madam Chairman. And I don't know that they're overstepping, since we gave them statutory authority and flexibility. So I just want to be clear. I feel like when I said they went rogue, it was more in the sense that they are going against the intent of the legislation at times in these rules and regs. So, but we did give them authority, so it is on the legislature to rein it in. Thank you, Madam Chairman.
It's something we need to look at going forward, certainly at reforming how we do that. Yes, Representative Carmichael.
Thank you, Madam Chair. 2 brief points. First, I don't think delaying our deliberations on this regulation pending receipt of additional information would accomplish the purpose that some want, because they've had their hearing. They don't even have to have a hearing. If we choose not to have a hearing on a regulation, the agency just goes ahead and adopts it. If we choose to take no action, the agency just goes ahead and adopts it. we only have the power to say you adopt this regulation at your peril because the legislature will be back in January, and so will some of us. And that's the way that we control that type of overreach, unless the Attorney General changes his collective mind over there across the street and decides that this is outside the authority granted by statute. And the second thing I want to mention is I think one of my colleagues on the committee indicated that this had something to do with the administration. To the extent that may have been a reference to the governor's office, I would remind the members that one, this is not a cabinet level state agency. This is a so-called independent agency. And while governors may appoint members of a board, they have no supervisory authority and they can't stop the board from doing something. All they can do is appoint the members when there's vacancies. So a lot of the agencies we hear from are independent agencies. And as much as the governor might want them to do something different, she can't make them do something different. On the other hand, if it's a cabinet level agency, then the governor has power over the secretary. But this agency is not cabinet level. Thank you for hearing me out.
Thank you, committee. I think we're ready to proceed with voting on the motion. So one last question or comment, Senator Francisco?
Thank you, Madam Chair. I understand, and I'm wondering if the hearing is Thursday, July 11th, as indicated. So my understanding is action that we could take could happen before that date. And I would like to give Representative Wassinger time to see if we could get any comments back by that date. I think to me, that's more appropriate way to proceed. Because I think the motion is kind of asking someone to do something that's not necessarily in the rules. I think we can do that individually. I'm a little concerned that we would do that as a committee.
There was a reference that the motion isn't in our rules, but I think we have clarification from the revisor that we can entertain a motion that it be a recommendation of this committee to delay implementation of new Article 23. And that's the ruling of the chair that the motion is in order to, as a committee, make the recommendation that the recommendation that the Board of Pharmacy delay implementation of new article of new Article 23 to KAR 68 is the motion in front of us that has been seconded. Senator Francisco and then Senator Tyson.
Thank you, Madam Chair. My
Senator
question was
Bastido.
just if we would want to include a date or some idea to give them, instead of saying, please delay this, would it be helpful?
Very well. Do you want to amend the motion and the second, Representative Wassinger?
I think it's hard to give an exact date. I would say before July, what is it? What day are they meeting?
How
again?
about, I think the legislature is back in regular session January 13th, 2025. Do you want to make it something January 30th, 2025, so the legislature is back in session?
Sure. I would amend that to January 30th of 2026. 5, sorry. I'm trying to jump ahead.
Thank you. And the motion is seconded by, the amendment to the motion is seconded by Representative Sutton. Any further discussion? Senator Tyson, I think you had a comment. No, or discussion? All right then, does everyone understand the motion? Yes, okay. Then all those in favor of the motion signify by saying aye.
Aye.
All those opposed, same sign. Okay, so the The ayes in favor of the motion have it, and the motion is approved and adopted.
Madam
Does
Chair, I
anyone want
ask
to
that
be recorded as a no?
say no. Thank you.
Okay, Representative Carmichael does, and Senator Francisco wants to be recorded as a no. Okay, then we are ready to prepare with the presentation on new Article 23 to KAR 68. Thank you.
Thank you. I will keep this brief in the interest of time. 6823.1 is our definition sections. I don't think we'll have too many questions over definitions. 6823.2 handles telepharmacy outlet application facilities and managing pharmacies. This will set forth the requirements for pharmacy owners who wish to establish a telepharmacy outlet, including where it can be established, how many prescriptions can be dispensed, supervising requirements, and potential waivers from the board in certain circumstances to operate a telepharmacy. 6823.3 handles personnel, staffing, training, and supervision. And this will set forth the requirements for the aforementioned, how the outlet is to be staffed, internal inspections, storage of drugs and devices, emergency procedures, and what constitutes direct supervision. 23.4 handles the practice of pharmacy, and particularly the practice of pharmacy of a telepharmacy, when a prescription may be dispensed, and what tasks may be performed by pharmacy staff. 6823.5 handles the operation of telepharmacy outlets and the requirements for operating, when the outlet can be operated, what electronic prescription applications may be utilized, where the outlet receives prescriptions and devices, what notices and licenses must be displayed, and how often a pharmacist needs to be on site. And our final regulation is 6823.6, which handles structural, security, technology, and equipment requirement restrictions. This will deal with things like outlets, equipment, technology, plumbing and electricity, sanitization, lighting and climate for drug storage purposes, record keeping, and automated dispensing. That is 6823.1 through 6.
Thank you, committee. Any questions or need for further explanation of any of the proposed regulations in new Article 23 to KAR 68? Not seeing any, then I think that concludes the regulations and revocations proposed by the State Board of Pharmacy. So unless we have further questions for Mr. DeYoung, yes, Representative Wagner.
One clarifying question. A lot of your regulations deal with what's called a telepharmacy outlet. And so telepharmacy is not just, and again, pardon my if I'm just totally not tracking with this, but telepharmacy, I would presume it was like telemedicine. You know, you're talking to a doctor. I would presume that would happen in somebody's home. But a telepharmacy outlet, there's an official outlet where this happens, like a kiosk or something, or what?
Not quite a kiosk, more of a building, but to break it down real quick, we have the managing pharmacy, which is the pharmacy where your normal pharmacy, right?
Okay.
And then you have the telepharmacy outlet. The outlet is where telepharmacy occurs, and that's because you need to have storage of drugs at the telepharmacy outlet.
Do these regulations have anything, any impact on, I believe there's a procedure, a term of art, if you will, in the pharmacy world, white bagging. Does this have anything to do with that
No.
term? Okay, no. Okay, thank you. Any other questions? Seeing none, then thank you very much for your presentation today. And I know, I think Representative Wassinger has one other question that before I conclude, we'll let her ask.
Thank you, Madam Chair. I would ask the Board of Pharmacy, in particular, Mr. DeYoung, it just seems kind of arbitrary with the distance and the pharmacy prescription limitations. Where did they come from, and what is the reasoning behind that? Do you have other instances of boards throughout the United States that feel that this isn't entirely necessary? And I would like to say, while it's not necessarily white bagging, I think it could be described as brown bagging. So thank you. I would like the answer to that.
I'll start with the back half of the question and then work my way forward.
Make sure you speak into the microphone so those online can hear.
Terribly sorry. I will start with the back half and work my way forward. As it relates to brown bagging, it does not. Brown bagging relates to sending a prescription to a home address, which is not what telepharmacy is about. So we are not dealing with anything related to white or brown bagging when it comes to telepharmacy regulations. As it relates to the first half of your question, which is the distance requirements, I will tell you first and foremost that there are several other states that have adopted telepharmacy, and there is no true unifying thought between how those different states have adopted telepharmacy. We have seen quite the gambit for their particular either statutes or regulations, depending on how that legislative body works. As it relates to how we came to our distance requirement, that was because the board met with stakeholders, and there are plenty of stakeholders who feel one way and plenty who feel the other way. And the board looked at these requirements for distance and ultimately decided to do so in order to ensure patient safety, as that was the foremost concern for our board, is patient safety. Anything further, I think you'd have to ask the Board of Pharmacy, as that was their decision, not mine per se.
Thank you, Representative. Do you have further questions?
Well, I apologize if I tried to make it sound like brown bagging. I was wrong in that, but I don't, if this is supposed to, as Representative Sutton remarked, access to care, you are limiting access to care by these regulations. So I do have a problem with that. And so I don't see how you are expanding access for Kansans to get medications. Thank you, Madam Chair.
Without the proposed regulations, has telepharmacy been operating in Kansas?
The only telepharmacy that is operating in Kansas is under a pilot program. That pilot program was originally set to expire when, and Representative Carmichael, please don't sell yourself short. It was approved twice. The first time was back, I believe, in 2023, and the second time, of course, is late 2023. So the first time it was approved and we were before this committee, we had a pilot program that had been active for several years, but was set to expire upon the adoption of these regulations. I believe the pilot program was extended due to the fact that the regulations did not have the AG stamp at that time. And I believe the pilot program is once again set to expire upon either the adoption or rejection of these regulations. So I'm not 100% positive on the exact expiration date.
But the pilot program will remain in place until these proposed regulations are either adopted or rejected, is what you had just said, correct?
So.
Okay, so we're not doing away with telepharmacy while these proposed regulations are being considered, because we have the pilot program operating.
Yes, I believe
okay.
There's one, maybe two outlets that operate under telepharmacy pilot program right now. So we are very limited in terms of how much telepharmacy is currently in the state of Kansas.
Right, which is why it's important that we get any proposed regulations correct. So with that, if there aren't any other comments or questions for Mr. DeYoung, who has been at the podium a long time, but thank you for your presentation, and thank you for standing questions and appearing here in person today in front of the committee. We appreciate it. Thank you. Committee, we are a bit behind our schedule now, so while we might otherwise take a quick break, I think we can get through the Kansas Department of Health and Environment Division of Healthcare Finance regulations, hopefully pretty quickly. We'll see how it goes. We may need a break in the middle, but we will ask Brian Vasquez, General Counsel, to the podium. Please introduce yourself and welcome to committee.
Thank you very much, Chairman Warren. As you indicated, and I've appeared before the committee before, but let me make sure that all of the people from Kansas Department of Health and Environment are here so that the committee knows. My name is Brian Vasquez. I'm general counsel for the Kansas Department of Health and Environment. I have been with the Medicaid program since 1992. So that's my area of forte. But to help me today, I have Dorothy Noblet, who is the senior manager for fair hearings and grievances for the Division of Healthcare Finance. In reality, when you hear the Division of Healthcare Finance, that's Kansas Medicaid. I also have on the back row Ashley or Yvonne Case, who is the director of operations for the Division of Healthcare Finance, and Ashley Beeson, who is the director for legislative affairs for the agency. What is being passed out for the committee's consideration is actually a large set of regulations, and I don't know of any way to avoid saying that. A little bit of background, it's included in the testimony. I'm not going to read it. The committee can read it, but to be real fair, the agency currently handles fair hearings using a set of regulations that were originally adopted by the Kansas Department of Social and Rehabilitation Services in the late 80s and early 90s. Probably dating myself, but at one time, SRS was the public welfare agency for the state of Kansas. That was the concept that Dr. Harder had. If it involved public welfare, it ended up going through some door at SRS. We have moved on from that. In 2005, approximately, the Kansas Health Policy Authority became the state Medicaid agency. In 2011, the Kansas Health Policy Authority terminated as a result of Executive Reorganization Order 38, and the Kansas Department of Health and Environment and the new Division of Healthcare Finance took on that responsibility. That is where the current Medicaid authority in Kansas exists. The problem, I used a word, we probably put quotation marks around problem. The issue is Medicaid itself hasn't stayed the same. As this committee probably knows, we adopted a fairly large program of managed care that began in 2013. It was known as CanCare. It brought some new players to the table. We have managed care organizations and basically an insurance company that has its own set of providers. Approximately 95 to 96% of all of Kansas Medicaid was then assigned to CanCare. But there were still groups of people who received services through fee-for-service. During that time, there's also been changes to the way the structure is. But trying to use the original fair hearing regulations from the late 80s and early 90s just was not up to the task. And to be candid, the agency has spent a lot of time trying to make sure we had everyone's input. We've discussed this with the Kansas Department on Aging and Disability Services and the Office of Administrative Hearings. And we're not trying to supplant the Kansas Administrative Procedures Act, which is what normally controls all administrative hearings in Kansas. But there are some requirements at the federal level that are not really covered by CAPA. One might be the what's known as an adverse benefit determination, which is something that the managed care organizations, per federal regulation in approximately about 2016, were then required to do. But that provided a pathway for due process purposes into a fair hearing at a state level. The chart that I provided at the back, and again, I did not know of a good way to graphically present this other than in that way. What we are really doing is suggesting administrative hearing procedures for eligibility and fee-for-service. Article 8 would be managed care, and Article 9 would be providers. Providers currently are covered by KAR 30-5s, which again is another large set of regulations that probably needs to be moved. Be fair, I almost need to stop now, and I would be glad to try to answer any questions because I do realize this is a large set. I can go through each one, but I don't think that that's necessarily the best use of this committee's time. But I'll be glad to try to answer any questions you have.
Thank you, Mr. Vasquez. We do have a question from Senator Faust Godot.
Thank you, Madam Chair. What you just described, the history of the regulations you're speaking of. So even though the entity has changed somewhat, would it still be applications or applicants applying for Medicaid through formerly known as SRS, now DCF? Would those be some of the individuals that would be requesting this fair hearing?
With one little bit of clarification, you are correct. The when you apply for Medicaid in Kansas, you are actually applying through the Division of Healthcare Finance. That is the Medicaid agency. The Kansas Department on Children and Family does not have a Medicaid role, even though they are a significant partner. Foster care children are an example. But this does not change that application process. What this does provide, specifically in Article 7, is the way for a person who is not happy with the eligibility decision that the agency made to contest that decision. Does that answer
Chair,
your question, Senator?
It does somewhat. Thank you.
Thank you.
Thank you, committee. We have another question from Representative Carmichael.
Thank you, Madam Chair. Good morning, Mr. Vasquez. Nice to see you again.
Nice seeing you, sir.
First, I have to observe that the name Robert Harder is probably one of the oldest, and I don't know if most revered names, most cited names that I can think of in Kansas administrative politics. I can remember when I was in junior high, my father would say either good or bad epithets about Dr. Harder, depending on how a decision was made. And I'm well over Social Security age now, so I don't know what that tells us. My more substantive question, however, is can you give us a few highlights or examples of what you would consider to be important substantive changes in the fair hearing process? Because I'll confess to you that I did not read every page, but if you can just give me something of a flavor of the types of changes that we are making here, it would be helpful to me.
Sure, I'll certainly give it a shot, sir. There are several decisions that can be made by the Medicaid agency that affect both applicants and recipients. What this is designed to do is to provide, hopefully, clear pathways for them to follow. For instance, if you're applying for assistance with your nursing home and the agency says no for some reason or another, that would probably go through Article 7 because you are an applicant seeking assistance. By contrast, if you are a person who's already on Medicaid, already in CanCare, and your particular managed care organization says you've requested 20 therapy sessions, we don't think that's medically necessary. We're only going to approve 10. That would be an adverse benefit determination, and that would go through Article 8. Article 9 then deals with the providers. I have had a number of hearings where individuals who are disabled needing to use a motorized wheelchair that, for whatever reason, wears out, the provider then usually helps that person, and they say, here is a new wheelchair, a motorized wheelchair, and we believe that you should be able to receive that. That is sometimes a provider appeal, and that would be an Article 9. Another issue that is here is the legislature in 2020 became concerned with some of the decisions that managed care organizations were making. And there was a statute that became codified at KSA 39-709I, dealing with independent third-party review of provider decisions. And that's a hearing that's authorized by, or was at least regulated by 129-9-9. And so, to be fair, this was an attempt to handle as many of the administrative hearings that Kansas Medicaid faces in a way that if a person needed to know what the procedure was, they knew where to go. One of the issues, and this probably may be getting too much into the weeds, and I'll apologize, but for the attorneys, one of the questions that we run into regularly is who is the real party in interest in some of these hearings? And that's why there is a specific section in both Article 7, 8, and 9 to help identify who those parties are. Article 8 goes into some detail to discuss the managed care entity, which is our phrase for the managed care organization. I don't know if I'm answering your question, Representative Carmichael, but I'll be glad to try to answer a very specific question if you have one.
Madam Chair, with your leave, and I do appreciate the explanation of the types of things that may present themselves for determination under a fair hearing process. I'll try to be specific about what my concern is. One of the things that lights up my email box is when someone believes that CanCare should, for example, provide them with a motorized scooter, and a determination is made by the managed care organization that it's not medically necessary. And so people write to their representative and they say, why can't I get a whatever it is? Okay. How is this going to streamline the appeals process? Is it going to change the appeals process? Am I going to need to give my constituents different suggestions as to, and by the way, I don't practice law anymore. I'm retired and I sure didn't practice law for free before. So I'm not going to be their lawyer. But is this going to change the sorts of things that I need to tell people to do to take an appeal? For example, from the managed care determinations, which are a particular thing that lights up a legislator's mailbox.
And I have been on the receiving end of those sort of legislative inquiries on behalf of a constituent. In general, no, it should not change your advice, but it does provide a few other options. You will notice, for instance, there is a section, if you look at 129-7-3 on the chart and flowing across on 8-3 and 9-3, dealing with grievances. Grievances is kind of a new term that got added at the federal level. It's not included in CAPA, but what a grievance is that where it may not necessarily be a substantive issue, but it is something where you are not happy with the way that the managed care organization is providing services. It's maybe a little hyperbolic, but let's say you received the doctor's visit, but you were not happy with the doctor you received because they had horrible bedside manner. That would be a way to file a grievance. It's not where you were denied something and you were contesting that, but you have a way to at least express your displeasure. And that is actually a federal requirement that we have now attempted to add into the regulatory procedure.
So by way of example, a grievance, does it rise to the level such that if the grievance is denied by your agency, that there's appeal under the Administrative Procedures Act for a grievance? I didn't like the way the doctor looked at me on the day of my visit. How's that going to work out?
That probably would not rise to the level of a fair hearing, but I'm going to turn to Dorothy just to make sure I'm not saying it incorrectly. A fair hearing is for an action, and I'm sorry to get into the weeds here.
No, this is the weeds. Frankly, this is the weeds I'm looking for, yes.
An action by federal definition is where you have made a determination that affects that person's rights to benefits or something. It can be a reduction in the service or something. If you go along and say, I did not like the doctor I received because, he hadn't shaved that day and he, his hair was greasy. That it probably would not go to a fair hearing, but grievances are tracked by the agency as the state Medicaid agency to see how well a managed care organization responds to those grievances. And there is a clearance rate that is on that. Dorothy is shaking her head. Yes.
Clearance rate meaning?
I'm sorry, sir?
Clearance rate meaning what, sir?
I'm sorry?
I think you said there is a clearance rate, and I was asking what clearance rate means.
They basically reviewed it, examined it, and made a decision, and hopefully it is no longer a grievance with that person.
Finally, Madam Chair, if the nature of these regs, they deal only with the healthcare financing administration portions of KDHE.
Yeah, they only deal with Kansas Medicaid, sir.
Okay, so things about disposal wells or any of the other many things that KDHE gets involved in, they're handled in a different set of regulations.
That's correct, sir.
Okay, thank you very much for your time.
Thank you. Representative Penn.
Thank you, Madam Chair, and thank you, Ms. Vasquez, for being here and for giving us the background and the history. It's very informative for someone like myself. I don't have a lot of dealings with it, so I truly do appreciate it. And Madam Chair, I don't want to be acrimonious or anything like that, so please don't take it that way. But I did open up the packet, and I know that we're doing this expeditiously, and it's quite a large packet to try to digest. And I'm seeing some things in here, and then I'm going to make a recommendation after that. When I open up to this is dealing with 129-8-5. It's basically in the middle of the packet. 129-8-5 talks about continuation of covered services for MCE enrollees applicability. Just a couple of things in here. When I go to paragraph E, subparagraph 3, I believe it is here. 4 says if the enrollee fails to request a state fair hearing and the continuation of covered services within 10 days, the covered services continued pending the appeal of the decision shall end 10 days following the sending date of the MC's adequate notices of appeal resolution. I know that we have many constituents, as the prior representative was speaking on, who are concerned about the programs and the benefits that are allowed for them. And sometimes there's a lag in communication. Sometimes there's a lack of knowledge on how to access, who to talk to, things of that nature. And I'm sensitive to, while I may not necessarily be enrolled in the program, many of the people that I represent are. And they want to make sure, I want to make sure on their behalf that we don't get into legalese or administrative jargon that they might not understand, right? And leave them in a glitch where they get their stuff cut off, according to the regulation, right? And if we push over, if you will, to the next page, let me see, where was that part that I was looking at? I think it was subparagraph 7, delta 7. It said, if the final resolution of the appeal or the state fair hearing is adverse to the enrollee and upholds the MCE's adverse benefit determination, the MCE may institute recovery procedures against the enrollee to recover the cost of any non-waiver covered services furnished to the enrollee to the extent that the covered services were furnished solely by reason of this regulation. To me, that's a little intimidating, a little precarious, because if someone, to the earlier point, gets an adverse resolution when they come to this appellate authority, to the board, then they could actually, I don't see anything in here saying that as measures step down, they could go bankrupt if those costs are going to be recovered. So if you could speak to that, first of all, and allay fears on that and explain exactly how that happens. But the bigger point is this particular thing that you brought before us today, all 3 sections of it, 7, 8, and 9, may be replete with these types of snags that we don't fully understand. And Madam Chair, what I would recommend or move is that we would break this up into perhaps 3 meeting dates and break this thing down so we can actually digest it. And it's not to say that you're wrong. It's just saying, hey, we got some things in us a lot right now.
No, I'm sorry. No, I appreciate that. And it's, to be fair, we had some discussion as to how to present this. We do have a public hearing coming up on July 5th. And so I hope to have fairly good comment, even if it is just after a holiday. The last time I checked, there is a fairly large number of fair hearings. I'm going to get back to your question in a minute, where we are now 800? we basically have had 800 requests for fair hearings this year, and this has been a low year. When CanCare was initially started, we had several years where we were over 2,000. And what we found from that is the more people understood, maybe the easier it was to handle. The continuation of covered services is actually what we've taken is some language from the federal law, and I believe it is from 42 CFR 231. I believe it is 230, where the federal law says that if you have a continuation of services because you think the agency is wrong, you go through the fair hearing, and the agency is proven to be correct. The federal law does allow, or at least a federal regulation allows the agency to recover the cost for that continuation of services during the period of time until we get that decision. From a practical standpoint, I don't know that I've ever had the agency take that option because, as you correctly point out, the vast majority of people, and there are some exceptions, again, to be candid, but the vast majority of people are judgment proof. They do not have, a motorized wheelchair. Those can run anywhere from $8,000 to $20,000 easily. They don't have the money to cover that, and so it's just a waste of time for the agency to pursue it. But if we did not have that included, the concern was that would that make the state regulation contrary to federal regulation, which then could potentially bring in CMS oversight. The discussion that this board had, or this committee had with pharmacy, I thought was interesting because we also do have some oversight. Not only do we need to be sure that the Kansas Attorney General agrees with the way we wrote it, but we also have to satisfy the Centers for Medicare and Medicaid Services that our regulations are within what they feel is the appropriate federal law. And so that's why that language is there. But to be fair with you, Representative Penn, in more years of practice in Medicaid than I care to admit, I don't know that I have ever seen that option exercised.
Thank you. The bulk of the regulations from KDHE, Division of Healthcare Finance, particularly Article 7, 8, and 9 are new regulations from what I understand. And Article 1 are some changes to definitions. And it is quite lengthy, and I wouldn't want to shortchange any of our discussion here. So what's the will of the committee? We can take a break and delve into this today since we're on a sort of a short time frame if the public hearing is July 5th. And then come back and do a deep dive after a 10-minute break. We can proceed expeditiously, or what's the will of the body?
If I could, at the committee's, discretion, I'm not planning any leave for a while. If I need to come back and present again further, I'll be more than happy to do so.
Thank you, Representative Carmichael.
Madam Chair, I would observe that, quite frankly, I don't need to take a deeper dive myself. I respect the rights of other members to take deep dives if they wish, and presumably come back to the surface. But if we're going to take a deep dive, we probably ought to take lunch and come back for a deep dive, or try to get rid of anybody else that's on our docket. And because we're getting paid for a full day's work, and if we need to get it done, we might as well get it done today. No reason to increase the costs to taxpayers or try to delay the proceedings. But I think if we're going to do that, let's go eat our lunch.
Okay. Well, let's take a quick change of course here, and we will hear from the Banking Commission. And while the committee considers at that time whether we want to come back after a quick lunch break and fully hear more thoroughly the Department of Health and Environment's regulations. So with that, we will pause hearing from the Department of Health and Environment, and we will turn to the Office of the State Bank Commissioner and invite Brock Roller, or Rayler, I'm sorry if I've mispronounced that, General Counsel, to the podium. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, and you got it correct. It is Brock Rayler. I'm very impressed. So I will try to be a bit brief. I know we're running a little bit behind schedule. Office of the State Bank Commissioner is we are a safety and soundness regulator, and we ensure that state chartered banks operate in a safe and sound manner and do not fail. Today we have two regulation changes to our state banking code, KAR 1711-18 and 17-11-21. I believe that both changes help reduce our bureaucracy and offer more freedom to state chartered banks. This was requested and agreed to by the Kansas Bankers Association. So just a slight deviation. These regulations will only apply to the 168 state chartered banks in Kansas. It does not apply to any nationally chartered bank, any savings and loan, any credit union, or mortgage company that's operating in Kansas. Of those entities, I believe that the state charter banks have the most strict requirements, so we are helping to curtail and get state charter banks closer to a level playing field. KAR 17-11-18 discusses loan documentation requirements. What we are proposing is for non-purchase real estate loans for $250,000 or less, we would allow a state charter bank to conduct a lien search as a minimum loan documentation requirement. That would be simply someone going to check to make sure there's no additional liens on the property. The reason that we're proposing that is this is already permitted for purchase money real estate loans where title is changing from one person to another. Non-purchase real estate loans, generally title is not changed because that would be a refinance or a second mortgage. Another thing that came up is we did want to clarify that for purchase money real estate loans where title is changing for $250,000 or less, it would meet our minimum requirements for title insurance, title opinions, or mortgage priority insurance. We do not also require lien searches in those instances. That's always been our policy, but we're putting it in the regulation. Next, we are proposing some changes to 17-11-21 for appraisals and evaluations. This is to mirror what national banks can already do. So there's nothing here that does not apply to a national bank, although they're not subject to this regulation, and it just mirrors what they can do. So what we are proposing is state banks may conduct evaluations. Those are done by officers of the bank or someone that's independent to the transaction to verify what they believe the value is. That does not mean that the bank or any consumer is prohibited from getting an appraisal if they so choose. In fact, subsection A states that an appraisal is required unless the bank is able to fully comply with subsection B or C. So this change will allow evaluations up to $250,000. I'm sorry, we're removing the $250,000 threshold and changing it for $400,000 for single 1 to 4 family residential properties, or $500,000 if it is not. And also, there's another change that we are making. It's technically not federal law, but it is in their guidance that if you have a master loan, you can look at each individual property separately. And if that individual property would require an evaluation, you may do that. So essentially, these big construction companies will have 10 to 15 real estate loans in the master loan. We would look at each individual property, and if it meets that threshold, they can do an evaluation. They don't need to get an appraisal just because the master loan is in the millions. With that being said, we did issue the notice of public hearing and 60-day notice in the May 23rd issue of the Kansas Register. Hearing is scheduled for July 23rd at 9 a.m. At this time, we have not received any comments to our proposed rule changes. And with that, I'll stand for any questions.
Thank you. Committee, any questions? Not, oh, excuse me, Senator Tyson has a question.
Thank you, Madam Chairman. I'm sure this keeps you in federal compliance. It doesn't take you out of any investment vehicle issues with federal compliance, would it?
Are you asking, are there any issues with the federal law for vehicle financing? Well, these regulations would only apply to real estate loans as it is. I'm not aware of any issues with the federal laws. And I'm certainly not aware of any federal bank that's had a failure due to conducting evaluations in lieu of an appraisal.
Go ahead.
I'll yield. I will yield to Representative Carmichael, and then I may have a follow-up.
I didn't mean to jump in line, Mike. Just quickly, your financial analysis or statement says that the Office of State Banking Commissioner discusses regulation with the Kansas Bankers Association, Kansas Land Title Association. Did they have objections? Do they think this is the best thing since sliced bread? What were the results of those discussions?
Yeah, very good point. Thanks for bringing that up. The Kansas Bankers Association is the one that requested these changes to begin with, which we agree with. Kansas Land Title Association, obviously, they were not as happy with the changes.
Title insurance.
Yes.
Did they have specific complaints or objections as to something that's technically done wrong here, other than the fact that this could cut into their business?
Their objections were mostly related to they believe that there would be a reduction in business.
Okay. They know where to find me. Thank you.
Thank you, Senator Tyson.
Thank you, Madam Chairman. I think they might have some other concerns too. And I think that one of the things that we haven't really seen in Kansas yet, but we are seeing in other states, is the theft of property through false records and documents. And I'm not so sure this is a good way to go, since the title insurance company is very in-depth for doing that research. And I'm just not sure. So where does the liability go then if there is false documents and they're not captured? We know the title insurance company holds some responsibility at this point. And so I just have some concerns over this.
Well, in this case, the liability would go to the bank and possibly the consumer, depending on what specifically is being included. If that is concerned, I believe a statute that applies equally to state banks, national banks, and credit unions would be the appropriate way to get that addressed. But as it stands right now, I'm not seeing a whole lot of that with the other entities. But if it's uniformly applied to all entities that engage in mortgage loans, then I think that would probably be the best way to go.
I would be concerned also about who has liability to make sure that there is clear title that can pass in the sale and purchase transaction, if not the title insurance company. You said it might fall to the bank or it might fall to the consumer.
Well, already for primary mortgages, there is no requirement to have a title insurance or title opinion. So this would be a refinance or a second mortgage. And generally, the reason I say it would fall to the consumer is they would have additional liens put on the property that they may not know But this would just be added on. The bank, instead of thinking that they would have second priority, maybe they have third. And if the consumer is judgment proof, then, you know, where are they going to be able to collect it?
Thank you for clarifying. Committee, further questions? Not seeing any, then thank you very much, Mr. Rayler, for your presentation today and appearing before committee. Thank you. And committee, we will now then turn back to the Department of Health and Environment, Division of Healthcare Finance. We all have had the materials presented to us for some time prior to today's committee meeting and an opportunity to spend time reviewing those. And is there any ability for the department to change the July 5th public hearing date to a later date? Or if that is set, then I would ask for the committee, having had time to review these proposed regulations ahead of today, that questions be asked today. If there's no
Candidly,
ability
I
to
need to
move
go
to
and
July.
I need to go and look again at the KSA 77-400s, which would deal with promulgation of regulations. The only thing that is coming to mind, and maybe the legislative research team can speak to that, the public hearing only has to be more than 60 days after the notice of public hearing. So what's running through my mind is that if we change that July 5th, I would need to go ahead and do a new notice of public hearing. And I don't know whether that would require another 60-day waiting period or not.
While the revisor looks into that, we have a question from Senator Faustido.
Thank you, Madam Chair. And believe it or not, I did look through my package in advance, but I had one lingering question. On the second page of the blue handout, if the gentleman could just clarify, in Article 7, what is your definition of this group? Thank you, Madam Chair.
I see that. Thank you for bringing that question up as well.
We're in Article 7, or I'm sorry. Thank you, Jill. I'm sorry. I must be feeling a little dense here. I'm maybe like Representative Carmichael. I haven't had enough coffee yet. I guess the question involves the phrase group or the word group. Where is that found?
Madam Chair and sir, it's in Article 7, and after the eligibility and fee for service, it says this group, and then it etc. But I just want your definition of the two words, this group. Who is this group? Madam Chair?
Yes, Senator.
I didn't know I was going to stump the panel. I just wanted the inclusive definition of this group. So does this group mean people who are filing these grievances, or does it mean this group of regulations? You've got a lot of numbers behind that. I just wanted that clarification.
Sure.
Thank you.
Article 7 generally deals with eligibility and fee for service. And so we would be individuals who would be either filing for eligibility and maybe contesting it, or for fee for service.
Thank you for that clarification, sir.
Thank you, Senator Francisco.
Thank you, Madam Chair. And it may be a group of the proposed regulations. So this is on the third page, where it talks about medical assistance grievances and state fair housing hearings for eligibility and fee for service. This group, and I think it's the group of regulations, not any group of individuals.
I believe that's correct.
Having been recognized, I would just add my comment that I think that there's a very logical reason for what is being done in terms of these regulations, and understanding what that would be. At this time, I would be comfortable ending the hearing, but if individuals on the committee have particular concerns, asking them to bring it back at another meeting for discussion and seeing if those are to the level that the committee would like to recommend changes in legislation.
Thank you. And nothing here today would preclude the legislature going forward with changes in proposed legislation in January and thereafter. Representative Penn.
Thank you, Madam Chair. As I spoke to the chair during the last presentation, I am sensitive to the time, and we want to make sure that we're on time. But I would like to also have the ability, opportunity as we go through and comb through this, trying to understand this, Mr. Vasquez. You've been a wealth of knowledge. Would love to approach you and your team if there are other things in here that raise hackles, because we want to be able to, while we legislators and lawyers can get into the legalese quite fluently, people on the street level understand it on the street level. So to allay any fears that they might have, I would love to come to you and just get the correct understanding so we can preach that back into the streets. I don't necessarily think, or as I said before, we're not saying that there's anything wrong or acrimonious. It's just more for a more complete understanding. So, Madam Chair, as I said before, during the last speaker, I'm comfortable with going to talk with them offline if that's the will of the body. Thank you.
Thank you. Do we have any member of the committee who would like, we all do have that same opportunity to speak offline with the department and have had the opportunity to look at these regulations prior to today. And if we could get an answer from the revisor about would delaying the July 5th public hearing already scheduled, how would that impact the department and the implementation of these proposed regulations?
Thank you, Madam Chair. So the exact wording of the answer is not in the statute. However, the statute does require that public notice of the public hearing needs to be published in the Kansas Register, and depending on their scheduled publication, that could take about 2 weeks for that notice to go out and to be effective, which if we look at the calendar today, that would put you at July 4th if it's 2 weeks, from today. So we're kind of pushing the timing, as that were, without me contacting the Secretary of State's office and knowing when that notice could go out. It's something that can be done. Pushing a hearing back can be done, but you just have to go through the mechanisms to get notice out to the public that the hearing date is being changed so that they can be adequately notified ahead of time.
And with what we have in place right now for July 5th, those procedures have been followed and the public has been duly notified that any questions that a person has can be brought to that public hearing July 5th, 2024. At what time and what place, please?
9 a.m. and it is in room 900N, which is in the Landon State Office Building. It's where the Division of Healthcare Finance has pretty much that entire floor, along with it.
What's the street address of that building?
900 Southwest Jackson.
900 Southwest Jackson, and you can find that at the first page of the documents that were submitted to the committee, which are also public documents for the public to look at. And they can also review the regulations that are being proposed. With that, then, if there aren't further questions for Mr. Vasquez, then we will ask that his portion of the meeting today be concluded. Do we have any other questions? Not seeing any. I have one final. Is the procedures the Department of Health and Environment is proposing, are these pretty standard? I mean, are these pretty standard procedures to address the hearings, the grievances, and reconsideration?
My opinion only, but I believe it is. It's one of the reasons why we wanted to make sure that we had Kansas Department on Aging, Office of Administrative Hearings look. I did also look at the administrative hearing procedures for both Missouri, Oklahoma, and Iowa and Texas, and actually borrowed some ideas from them. So to answer your question, again, my opinion only is I think these are fairly standard. They're not so outre that we're trying to undo CAPA or other things like that.
Thank you. With that, then, committee seeing no further questions or comments, thank you for appearing today in your presentation. The committee appreciates it. With that, then, we have a staff review of the law that the legislature passed in 2022, HB 2087, and reports for this year 2024 received to date. I believe a chart has been prepared, and we will hear from the Kansas Legislative Research Department, Ms. Shelley. You've been in committee, so I won't say welcome, but I'll say thank you for being here and thank you for the work you do for the committee. And please proceed. Do introduce yourself.
Thank you, Madam Chair. Jill Shelley, Legislative Research Department. We have received 3 reports for this year's group of House Bill 2287 reports. I just wanted to bring these 3 to your attention early on because it appears that 2 of the 3 agencies have a bunch of rules and regulations that are no longer necessary and could go through the expedited review process. Later this year, of course, we will have a full report on the other agencies that have been submitted. We chose to print out these 3 because they could come up very quickly for your review. And also they're very short. And so we could print them out. For example, the Savings and Loan Department had about 30. Mr. Vasquez and his team are reviewing approximately 3,300. So I just wanted to bring these to your attention, and I'd be happy to answer any questions.
Well, we should have asked Mr. Vasquez how that review's going. If you're reviewing 3,300 of them, how is that going? While you're still here, if you'll reintroduce yourself, that'd be great.
Yes. Well, let me just, for the record, my name is Brian Vasquez. I'm General Counsel for the Kansas Department of Health and Environment. And the team of attorneys is reviewing. By the time we got to our final count, we were a little bit over 2,200 regulations. Most of them were in Agency 28, but we also had regulations dealing with mining and also with the Division of Healthcare Finance, which is Agency 129. I have, there's one section in the environmental area that is still to be done, but all the rest are done. I had set a kind of a soft date that I wanted everything done by about June 20th so that I could have program managers review it. So I think other than that one section, I think we are done for the most part. It was candidly with this group, there were a number of regulations that we will probably try to pursue on an expedited revocation basis. We found one, for instance, that I'm still not sure why we have it, but KDHE had the responsibility for inspecting mausoleums. And I'm trying to figure out why we have that when we have the Board of Mortuary Arts.
Thank you. Committee, any other questions for Ms. Shelley regarding the agency's review? Senator Tyson.
Thank you. Not a question, but a comment. Thank you for your thoroughness and all your work. That printout is excellent, and also the revocations for us to be able to easily look at that and not try to read through the rules and regs online. That was very helpful today. Thank you.
Sorry, I thought I had sneezed. Yes, thank you for preparing the chart. It is very easy to reference about how the review is going and how the bill, as passed by the legislature and enacted into law, is helping to bring some oversight to rules and regulations. And I hear often that, why so much government red tape, and make sure that we have as much as necessary, but not anymore, because it is a burden to Kansans, both in the businesses and as well as other areas. And we need to make sure that as best we can, that the process that we have made significant reform to in 2022, that it's being helpful in making it a good place to be in the state of Kansas. So thank you for putting this together. You can see it's rather expansive. I'm kind of showing it up for anyone looking online, but and you can find this document as a public document as part of the committee record. So
Yes, Madam Chair, we will be posting them online as we did last year. I know we've had multiple requests to have these printed out, but last year's set, which is anticipated to be smaller than this year's set, would have taken approximately 400 ledger-sized pages. So that's why you didn't receive them in the mail.
that would be a lot, but I appreciate the work of the legislature in 2022 to bring this reform to how we review rules and regulations in Kansas. So thank you for being part of that as well. Committee, before we get to our report for today, want to circle back to approval of the minutes from the April 25th, 2024 committee meeting. We were waiting to have all members join the committee today to determine if they had any other additional changes, and to ensure specifically Representative Carmichael the opportunity if there was any change needed to being recorded as absent from the meeting but excused.
I was absent. I appreciate the members inquiring as to my status, but as I believe that was the morning that I had it wrong on my calendar. And I think I texted the chair and said, oops, and she was kind enough to excuse me.
Thank you for the clarification to the question that was brought up earlier about the minutes. Then I do believe we have a motion and a second already regarding the minutes. And if there's no further discussion on it, then you all have heard the motion. All those in favor signify by saying aye. All those opposed, no. The motion carries. And then finally, committee discussion and comments on the proposed rules and regulations. We'll first turn to the Department of Agriculture, Division of Animal Health. Any comments for the report of the committee? Not seeing any. Then the Board of Examiners in Optometry. None. Then the State Board of Pharmacy. We do have the motion that passed, so if we could get with the 2 recorded no's, if we could get a statement from Ms. Shelley about proposed language about how that would be stated in the report.
Jill Shelley, Legislative Research. Madam Chair, I would appreciate a little more opportunity to go back through my notes, but I believe it is, and we will check with the maker of the motion before I present anything in the report. But it is to request that the agency delay implementation of the telepharmacy set of rules and regulations until at least January 31st of 2025. 31st, excuse me.
I think it was actually January 30th, but I don't think anyone would oppose making it January 31st, just to be easy looking at the calendar. So So we will have a draft, or at least I'll have a draft of the report and can take a look at that particular language if the committee's comfortable proceeding that way. Representative Carmichael.
If we've concluded that particular concern, I have an additional concern.
Have we concluded that particular concern, committee? I think we have, seeing no other hands raised. Representative Carmichael.
This is not intended as a comment on the gentleman who appeared before the committee. I'm sure he's a fine lawyer. I, at least, and I suspect the committee as well, has concern about the necessity of the Board of Pharmacy having a full-time lawyer whose sole responsibility is rules and regulations. And I think we ought to just express a concern about that. And I think those who are on budget committees ought to keep that in mind when you look at the pharmacy board's budget, to inquire of them whether it's necessary, whether a proviso might be necessary. My final observation on the point is it is also concerning when the second regulation in front of us refers to non-controlled substances, and a full-time lawyer in charge of rules and regulations at the Board of Pharmacy doesn't know what a non-controlled substance is. But that does not need to be included in our report. I think we just need to express concern.
Thank you. Yes, Representative Sutton.
Just in reply, I'd like to assure the representative that the Board of Pharmacy will be receiving a great deal of attention this year, both from the Insurance Committee and as well as appropriations.
And I will rest easy knowing the representative is on the job.
And likewise, we'll be taking a look at that in the other chamber as well. Ms. Shelley, do you want to make a concise statement about what how that concern might be stated, or we'll look at it later in a draft if no committee member has a concern about what was just proposed? Not seeing any, then we'll take a look at that in the draft of the report. Any other suggestions for the report regarding the State Board of Pharmacy? Not seeing any. Any suggested comments for the report regarding Kansas Department of Health and Environment, Division of Healthcare Finance? Not seeing any, except Senator Francisco.
Thank you, Madam Chair. I think in this case, I would like to see if the other members of the committee agree that we make a compliment to the agency for looking, maybe we don't want to, for looking for a way to present the regulations in a way that's more usable for the public.
I think that's pretty vague, but
we could say to arrange the regulations in groups so that it's easier for the public to identify their place in, or, and Jill, maybe you could help us with this and we could review it. But
sure, to make.
But I think that was a really, I haven't seen that, to just say we're going to try to make this more usable instead of just focus on the regulations.
Yeah, yes, Senator Tyson.
Thank you, Madam Chairman. Why, I definitely appreciate the effort. My fear is that some of the agencies may go off the reservation so much in trying to make it better to, I don't know, it could backfire on us. But it's fine. We're just used to a certain method and a certain way of seeing it's fine, Madam Chairman. If you want to compliment them, compliment.
Can you restate what the proposed, Ms. Shelley isn't able to, but could you restate that, Senator Francisco, what your proposal is?
The proposal is to say that the committee understands the intent of much of the proposed regulations to be identifying the 3 articles and separating it by groups based on grievances, and we're hoping that that is helpful to the public.
I think they're just following kind of the statute and where KAR is already. So I'm not sure there's any other way to do that. So I'm not sure a comment would be what they would do.
I'm happy
Senator.
to make that comment individually.
Okay. Okay. So that won't be a recommendation from the committee then. Thank you. Any other proposed recommendations regarding KDHE Division of Healthcare Finance? Not seeing any. Then Office of the State Bank Commissioner. Senator Tyson.
Thank you, Madam Chairman. I don't know if the committee is in agreement or not, but I do have some concerns over, I don't know enough about it to say the authority. I know Senator or Representative Carmichael does it with his office and experience. Maybe has some more detail, but I do have concern over where this is moving.
Is that a recommended comment from the committee, or just wanted to state that? Thank you. Committee, any other comments or questions? Representative Penn.
I'm so sorry, Madam Chair. I'm actually going backward to pharmacy. Could we get a request from KLRD to know who's on that pharmacy board, please? Those members that comprise. Thank you.
Sure. Would you like that right now? Yes.
No, when they push out all notes.
Oh, if in the report would include, here are the members of the Board of Pharmacy.
Thank you, Madam.
I don't have a problem with including who is on the board. Yes, Mr. Mulholland. Ms. Shelley.
Jill Shelley, Legislative Research. Madam Chair, since the report goes to the legislature and to the agencies, could we just send that to the members individual or as a group? Would that be acceptable?
Sure, that'd be fine. Representative Penn thinks that's okay as well. Yes, committee, any other proposed comments for the report? Not seeing any, then I want to thank everyone for their attention. It has been a long 3 hours and stuck through it and with robust questions, and want to thank staff for putting on the meeting today and getting ready. And we need to also look at a proposed date for our next meeting, which Ms. Shelley tells me needs to be before August 23rd, before August 23rd. So if you want to bring up your calendars, are there, excuse me, yes, Senator Tyson.
Will it need to be sooner if, depending on the results of Representative Wassinger's findings?
Representative Wassinger, are you online? I think she had something came up that she needed to drop off, but considering her request and considering the public hearing is which date? July 11th. So is the committee considering July 8th is Monday after the holiday weekend? Are we thinking July 9th? I don't know what members are, where they're going to be, but I would suggest then, I would suggest July 9th. However, if everyone can be present July 8th, that could work as well. Well, let's go ahead with July 9th then. So July 9th, and will a report be ready to be issued before July 11th? Or is that's not going to be possible?
Depending on the length of the meeting and the succinctness of the review process, I believe we could. I mean, it'll be very tight.
And in any event, the meeting of July 9th will be public and will be recorded for the agency to be heard, for the committee to be heard, and for our comments to be recorded. So I'm comfortable with July 9th if the committee is as well. And we'll do 9 a.m. Yeah, I know. So there's no confusion. July 9th at 9 a.m. July 9th at 9 a.m. Ms. Shelley, does that conclude the agenda that you had helped us prepare for today? Excellent. Well, thank you again to staff for everything that you do to get us prepared, to get us our packets ready ahead of time. Thank you to the committee members for being ready with your questions and for being prepared. Thank you for our conferees for testifying, for those following along online, for those in the committee meeting room as well today, and Senator Francisco with a question.
Thank you, Madam Chair. I was just wondering if July 9th was a definite date or only if there is information to review.
We do have information already to review, is what I'm told by research. Is that right, Ms. Shelley? We do need to have a meeting before August 23rd. And this meeting can include,
So
this would be everything that we need to get done before August 23rd. Do we have it all?
So far, we have only one other rule and regulations that could be heard at that meeting. I have no idea what's going to be published next week, but we have one from the Department of Wildlife and Parks that I could be included in that meeting if they're available.
Well, if the meeting that Representative Wassinger is going to be requesting and the action she's going to be requesting of the Attorney General occurs before July 11th, would that need to come before this committee? If, for instance, the approval by the Attorney General is revoked before July 11th, would it have to come before this committee in order to, it would not. So we do not need to meet for that purpose. So I would say then, if we want to look later in August, yes, Representative Penn.
Thank you, Madam Chair. And I'm with that as well. If it comes back earlier, we can put that out via email to the group, and it stands by itself. And then I would propose that we meet after 6 August, but before 23 August, because a lot of us are on travels for pretty much the rest of July.
Okay. Does the committee want to take a look at August 7th, August 8th?
No, not the 7th.
Madam Chair.
Senator Faust-Godot, go ahead.
So I would prefer not to meet on August 5th. That is my birthday. And so the 8th sounds better if we aren't meeting on July 9th.
We are not meeting on July 9th, and we are considering the week of August 5th or the week of August 12th.
12th sounds better for me, but I can certainly join virtually.
I'm not firm yet on what my August plans are. Have a couple of kids to get off to college, but we'll take a look at August. Did we say 12th is what we were looking at? Okay. Let's look at August 12th then at 9 a.m. 9 a.m. So August 12th, 9 a.m. Yes, Ms. Shelley.
And I have just heard from the Secretary of State's office that we will have at least 3 more sets.
At least 3 more sets. So August 12th, those should be in, and that allows us to take a look at whatever else comes in before that August 23rd date. So August 12th at 9 a.m. So with that, then our work is done here today. Thank you, everyone. And